ಮುಂದಿಂದು ಫಸ್ಟ್ RFA was dismissed for non-prosecution. Had filed an application for recalling it. It was directed to be relisted in March. It's not been listed till now. Dismissed for non-prosecution, please.
Obliged.
Your Lordship, on
pertaining to court, my lord. Service matter, my lord, transfer matter, my lord. An appeal had been filed, my lord. All office objections have been complied. Now the government is initiating for further transfer, my lord. There is some urgency in the matter. Tomorrow, my lord. Fresh matter. Writ appeal. Passport.
Chief.
Please, my lord. Please, my lord.
Your Lordship, on writ petition, Your Lordship. Your Lordship, writ petition pertaining to service matters, sir. Division bench matters. May be permitted tomorrow or day. Writ petition, sir.
Correct.
Division bench matters. And one the Karnataka local. No, sir. Court has no. Two.
Sir, year, sir, ಯಾವ year, sir? Writ appeal ಯಾವ year, sir? Writ petition ಇಲ್ಲಿ ಬರಲ್ಲ, sir. ಇದು total one. SK total 3, sir. Total 3.
The three matters, writ appeal matters in the year 2020. The all employees, my lord, is other retired from service. That is, yes, my lord, my lord, was dismissed from service earlier. He approached the cooperative register, my lord. He succeeded, my lord. Thereafter, he filed respondent filed the writ petition. In writ petition is also dismissed, my lord. Now, my lord, the cooperative department, my lord, filed the writ appeal against the order passed.
You went before the learned single judge.
My lord, in 2019,
It's of this roster, now you want it listed.
listed for final view.
Take it.
Your Lordship, this is a criminal contempt matter of 1996. They had given an undertaking before the Supreme Court stating that they will not file any more suits. But after giving an undertaking before the Supreme Court, they kept filing frivolous suits one after the other. And since last year, the coordinate bench of this honorable court had posted it for framing of charges, Your Lordship. But then after that, they stated we'll settle the matter. But then they still did not settle the matter and they've been dragging on the matter, Your Lordship.
Which matter you are saying?
Criminal contempt, Your Lordship.
Is it listed today?
No, Your Lordship, we want to post it, posting.
What is the number?
6 of 2014, Your Lordship.
That's our roster. No?
Yes, sir, criminal.
We'll give you a convenient date.
31/7. Madam, 31/7.
Your Lordship, on short date, the parties are really old. They're 75 years old, Your Lordship.
How?
7 is it too long?
This week sometime.
We are 15 days away. It's all right.
Much obliged, Your Lordship.
Thank you. Yes.
Madam, Sabari.
Now we will take up court one first. We will start from list two.
With your Lordship's permission, if I may make a mention. That's list two, serial number 51,
We'll just come, ma'am.
please.
We are taking up those matters only. Just hold.
List number 2. List number 2, serial number 1. The Hirematad Maheshaya.
Just give dates.
Pray for weeks.
Yes, there were some objections we need to
Yes.
be.
I will comply within a week.
We'll just re-notify it. In the meantime, you do it whatever you have to do,
Please.
okay? Just give a date.
12th of August. Serial number 2. The Murugesh Charity. This is fine.
Same. 9, 5. Just give a date.
Twelve eight.
Just say this, office objections to be complied with before the next date of hearing.
12 8. Serial number 3. The Murugesh Charity.
Same order.
12 8. Serial number 4. Sri Naveed Ahmad. 4.
Same order. Same order.
Serial number 4. Contested. Contested of the 4 to 11.
What is that, ma'am?
4 to 11 accusers contested.
No, this is item 4.
Listed 2, listed 2, serial number 4, madam. Serial number 4. Listed number 2.
No, not.
Listed 2, serial number 4,
List
madam.
two.
Sorry. Serial number 4, Sri Naveed Ahmad.
Same order
13
to be
8,
complied with.
13 8. Serial number 5, Srimati Lakshmi Holla.
Pay for the petitioner only. My lord, in this on 1st March 2024, the government advocate had sought time to file to take instructions in regard to two or previous orders that have been passed by this court on 21st April 21 and 28th June 21, my lord.
This is in respect of the
But there are certain
medical
objections.
facilities to the senior citizens, your lordship.
But there are certain objections. What are the objections to be raised in the affidavit? We'll give you date.
Please.
In the meantime, just remove the objections. Whosoever has to remove it, it appears that filed by the counsel for the petition.
That is in respect of section 14, in respect of public.
We'll just re-notify, just have a look.
Please.
Re-notify.
14 8. Madam 14 8.
Yes, please. What's your place?
6. Srimati Maitreyi Krishna, 6.
Re-notify on.
14 8. 7. 7. Vijay AM. 7.
Re-notify.
14 8. Serial number 8, Sri Sundaresh.
Re-notify.
8. Serial number 9, Sri Arun BM.
Re-notify.
19 8. 10. Srimati Vijayata Nayak.
Here for the accused in this matter. Paying for time.
You appear for
Accused matters. A1 to A3.
A3. There are certain, I think,
We should file complaint.
objections. There are certain objections, I suppose. Just remove it.
File the affidavit. Paying for-
Re-notify on. We'll just re-notify it, just re-notify on.
18 8.
Grateful
Serial number
matters.
11, Siddesh. 11. Serial number 11.
Non-filing of reply by served A2. You are for A2 or A1? Re-notify.
20th of August. 12, Sri Nagaya.
For the complaint, my lord. The direction of the Samba court has not been complied by the accused. Direction dated,
You appear for whom?
complainant.
Complainant, no?
The order of
Renotif-
December
not
court,
no reply by served day 3. Is this?
we will have to examine this matter. Please.
Compliance affidavit has been filed? No, have you filed it in the registry or here? You have given him?
No, no. Precedent.
You have already filed it. Copy of the reply affidavit on behalf of accused number 3. No, who has filed this? We'll just say that a copy of the reply compliance affidavit has been given to the counsel for the complainant. That's enough. You want to file?
Please, I want to examine this, what the
Re-notify
stand they
all.
have taken in the,
August
what's your pleasure?
13, Nitin Prasad, 13,
I appear for the complainant.
Yes, ma'am.
Office objections with regard to compliance affidavit.
You have to remove the office objections. They
the
have to do
accused.
it.
Yes, sir.
Re-notify on.
21, 14, Sri Somsekhar, 14,
You have filed the compliance affidavit. Just have a check. Re-notify on.
serial number 15, Sri Sharath,
There is some office objections regarding by the respondent number 6, with respect to the Wakala.
Yes. Re-notify on.
22, 8, 16, Sri Rajeshwar,
I appeal for the appellant. It's 57 days delay in filing the appeal, my lord.
Service to the respondent is awaited.
Please, my lord, senior standing counsel for case IDC, Mr. T.P. Vivekananda is appearing for my lord. I request my lord, sir.
He'll issue notice.
Well, already the notice has been issued, my lord,
So that's incomplete, no?
incomplete, my lord.
Right.
Therefore, I may be permitted to take notice on the standing counsel, my lord, case IDC is.
Issue notice, the service on the respondent is incomplete. Fresh notice be issued to the respondent. Additionally, the standing counsel can also be served.
Please, grateful.
28th of August, 17, Sri Vachan, 17,
Re-notify on.
of August, 18, Ranganath Joyce, 18.
You appear for A2 for the state. So re-notify on. In the meantime, you file it.
328, 19, Sri Vigneshwar, 19,
Appear for complaint, my lord. 18, my lord.
You were to file some compliance report.
Yes, my lord.
You just remove those objections, re-notify on.
338, number 20, 20, Sri Raghavendra Gayatri,
Re-notify.
27, 8. Sir. 21,
I request a week's time to rectify the office objections.
You appear for?
Appear for at least 1 and 2, my lord.
You were to remove it.
Sorry, my lord.
You were to remove the
Yes, my lord.
objections.
There's some office
Okay,
objections.
then a counsel for the respondent number for the A1, A2, 6. How much time? 2 weeks?
Time, my lord.
A week's time to remove the objections, re-notify on.
27,
Much obliged.
serial number 22, Sri Subramanya Bhatt.
Re-notify on.
Serial number 23, Sri Vijay Kumar,
Dated filed by A2 and A3. You are for the
Complaint.
complainant.
Please.
You got the reply, objections?
They have filed, I have to examine.
You have got the copy?
They have given for the copy.
Re-notify on.
Please.
Venkat Subbarao.
Appearing for the accused number one in this matter, my lords, they may be permitted to file the English translation copy of the.
File it in the registry. The learned counsel for A1.
Yes, my lords.
A1 states that the translated copies of the Kannada annexures shall be filed in the registry during the course of the day. Re-notify all.
28, 25, Abhinav Ramanand.
You have to file reply, it appears. Re-notify on.
28, 26, Srikanta Gowda.
Appear for complainant.
And for the accuser, my lord,
Non-filing
while 2 weeks time is granted, my lord, we will file the compliance.
at the request of counsel for the accused. Re-notify to file reply. Re-notify. Re-notify.
27, Patil Sangana Gowda. 27,
Re-notify.
88, serial number 28.
I appear for the complainant.
Pardon?
This matter will be programmed 30th of this month.
Which one?
27 serial number.
Why there are any connected matters? Same impugned order. Yes, which date you said?
30th of.
30th July.
Yes.
These are those matters.
28,
I appear.
Just 1 minute. 27, give 30th July. Yes, ma'am.
8, Srimati Vinita.
I appear for complainant. In fact, your lordship, they have filed a compliance report, which is partial compliance. So I have filed today I am filing my rejoinder to that compliance report, your lordship. That's it.
The direction was only
Who appears for A1, A2 and A4?
I appear for the.
You appear
Yes,
for
sir.
that.
The order stand complied in this matter. The direction was only.
She is
that the-
disputing it.
The partial compliance, because my representation is very clear that a bund which has put across the stream, that has to be removed, and a private road which is on the forest land, which has been, that is where she has laid a road to her property, encroaching the forest land, which is in the bargain, she encroached my property also, and they put, with that regard, there is a report also.
You want to file a rejoinder?
Yes,
to
yes,
it?
I have, today I am filing it, your honor.
Learned counsel for the complainant states that she shall file rejoinder to the affidavit filed by the respondents, the respondent accused. Within how much time?
Today I will be filing.
During the course of the day. Re-notify on.
28, 8,
Macho.
serial number 29, Virupakshayan.
I appear for the state. I seek some time in this matter.
You have to file your compliance.
Yes, Your Honor.
The counsel appearing for the accused one seeks and is allowed 2 weeks to file compliance affidavit.
39, 8, serial number 30, Chandranath Gowde. Chandrakant Gowde.
Who appears? Anyone appears for the respondents?
I appear.
Then, but
You
Only
file
for
your
R1.
compliance.
In this, writ for, yeah.
Re-notify, just re-notify it.
59, 8, 31,
I represent the accused. We have filed but my submission, my lords, the order has been passed without giving me an opportunity of being heard.
Even the compliance,
Yes, my lords.
but that direction was there.
No, it has been clearly mentioned, undertaken exercise of fresh inspection and pass appropriate orders after providing an opportunity of her. So without giving me an opportunity of her, an order has been passed, my lord. So they have slipped short.
Yeah, so. We have noted that, na? Re-notify. See it next time.
59,
Please, ma'am.
97. Serial number 32,
I was appearing for the complaint in this matter, my lords.
A1. DBMP has passed.
I've not been served a copy with of the same.
Just give him a copy,
Yes,
re-notify, just remove.
58, serial number
Obligation.
33. Sanjeev PL.
My lord, for the petition, may I request for next week, my lord, some urgency in the matter, my lord.
That synopsis has not been served. I have served the
I
synopsis,
will-
my lord. That office objection may be over.
Right. When do you want?
Lord, but this week or next week, my lord,
Not
but,
this
Monday,
next week.
Monday, my lord.
Just give it next week.
47.
Much obliged.
These are all 33, no?
Yes, my lord, 33 are connected matters, my lord, two connected.
4, Pakshaya.
For the respondent state.
For
File the complaints affidavit.
Copy has not been given.
I'm serving the
Get the copy of the
That
compliance.
8 months have been elapsed, 3 months time, 2 months time was given.
Sir.
They have not complied there.
Have a look on the compliance affidavit.
Copy,
A
sir.
copy of the compliance affidavit has been served on the counsel for the accused who seeks time to look into the same. Re-notify on.
22/7.
Complainant.
35, government advocate.
This compliance is have been done, my lord. Let me check.
But you must file an affidavit, no?
Yes, I will.
Re-notify on. Just file your affidavit.
Sure.
29/7. 36.
My lord, notice issued to the fifth respondent returned with postal share refused.
He refused. You appear for whom?
That's I am for R1 and 1 to 3 minutes.
R1 to 3.
Please, minutes. And so,
You file your, this is okay, this is a writ appeal.
please, minutes. And
It is noted that the respondent number 5 has refused the service of notice. Hence the notice on respondent number 5 is deemed to have been effected.
sixth respondent, my lord, kindly dispense with my lord. During course of a day, I'm going to file a memo in this regard. I'm not claiming any relief.
What about R6?
R6, my lord, I'm not claiming any relief against the deceased sixth respondent.
So what do you want?
I want to, my lord, I will file a memo, my lord, dispense with service of notice, deceased sixth respondent.
No, you want to seek deletion, obviously he has
Yes, my lord,
expired
yes.
on, so
Yes.
it gets a bit, we'll stop. The learner, insofar as respondent number 6 is concerned, the learner counsel for the appellant states that he intends to file a memo.
Yes.
Mr. Re-notify on.
55/7.
My lord, this will be connected along with writ appeal 688 of 2024.
When is it coming?
Date has not been given, my lord.
So no,
Not
we
at
will-
listed, not at listed,
we will just only give a date,
please.
just make a request then.
Interim order kindly be extended,
Interim order if any to continue.
please.
25/7.
Right.
37, P. Shailesh.
Appellant in this matter. Lord, the only order that I'm seeking, my lord, is the petitioner is not the borrower, but she's the wife of the first respondent. She has come forward to repay the entire loan. Therefore, we filed an affidavit. Only thing is, we said that the discharge and the documents can be handed over to me. That actually does not find in the order. Therefore, the bank has said, since there is no order to that effect,
Order of the learner single judge.
Lord,
Order whose order?
Lord, the learned single judge's order,
Re-notify, just see, we'll have it after 2 weeks.
Lord, next week, my lord, because possession, they are trying to take possession of the property.
When?
There is an order. No,
When?
they have already got an order under the Surface Act. So therefore, if it could be stayed for a week and it may be called next week.
We will have it next week, Monday.
Please, my lord.
That will be convenient.
Please, my lord.
Leave it Monday, list on.
7.
I appear for the respondent state. These are on the green bench match.
Re-notify, we'll just give dates in all these.
Please.
matters. Re-notify.
Date ಬೇಕು sir. ಏನ್ ಬೇಡ.
Long day.
8th of August. 39. Madhusudan, Diga.
See, in this case, I have to, in compliance with the order, my lord.
I have to file a report. I am filing report in the course of the day in the office, my lord. With respect to further report, I filed an application for seeking extension of time.
But no, further means other than this report which you intend to file today.
Today, I am filing
Give a copy.
I'll
You'll
file
have it after 2 weeks. Re-notify.
5th of August,
Yes.
40.
Lord, I appear for the petitioner in this case.
We'll just adjourn it.
May I make one request, my lord? There is some urgency. Can it be called on 24th July, my lord? Because interim order from 2016 is being violated just now. I have filed the rejoinder also.
You want 24th, no?
24th, my lord. Great.
Hmm. 41.
It was slated for hearing by the court, my lord, sir. Any
Fantastic,
short
lord.
date.
Yes,
This
we
is a
notify.
suo moto PAL by the honorable court.
41.
This is the matter.
List
that-
on,
Some first week or second week, your lordships.
give it second week.
Very
My lords, I appear for respondent 8 and 9, my lords.
Petitioner.
My lords, there's some urgency in the matter, my lords. The petitioners, second round of PIL, my lords, serial number
Yes, which number, man?
42, my lords.
Yes,
I appear for respondent 8 and 9, my lords.
yes.
Next week, any date, my lords, there's some urgency, second round of PIL by the petitioners, my lords. And they themselves have approached the Honorable Supreme Court for disposal of the matter, my lords.
Yes, even give it next week is possible.
23rd.
29th, my lords, I may request for 29th.
29.
29, 7, sir.
I'm grateful, my lords. Obliged.
43.
I appear for the rest.
Green bench.
3rd September. 44. The Balraj.
Short date may be given next week, it may take.
No, my lord, this matter also.
This is also 30th July, you know, these are, I think, the same back.
Please. But,
PTCL matters.
Yes, my lord, petition.
but my lord, I don't have the interim, but in this, interim order is not there, my lord. Interim order may be granted. In those cases, my lord, interim order has been granted.
Lord, on better, would it not be appropriate? We'll have it on the same day,
Please, man.
30th July.
30th July, sir. Serial number 40, 45.
For the petition.
Re-notify.
59.
Lordships, instead of 5/9, there's some urgency in the matter.
When do you want, ma'am?
Lordships, it may be called on 25th of July, Your Lordships.
Not
Because-
15 days time may be granted because we are going to file an affidavit in the.
Just give it in August.
Lordships, at least 30th of July, there's some urgency, entire crushing activities
Give it-
to
just
stay,
give
Your
it,
Lordships.
Give it,
That's a reason, 30th of July.
30th July, give it.
30th.
Much obliged.
46. 14% K. Manjunath.
My lords, I appear for Union of India in this matter, my lords. My
Yes,
lords,
ma'am.
this is a matter that has already been disposed. This pertains to Kaveri water, my lords, under Article
But there is an
262.
order of recall, see, application for recall, ma'am.
Please, my lords.
Re-notify.
My lords, your lordships may post it any date after 3 weeks, my lords.
Yeah.
7, 8, madam.
Grateful, my lords.
Item 7, 8.
Grateful.
47, give a date.
47, I appear for petitions. It may be adjourned, Your Lordships, on
Pardon?
5/9, it may be adjourned.
Just.
59. 48. Another hearing.
Appellant, my lord. Here
48.
for the appellant, my lord. This case.
Just give a date, ma'am. Yes.
39. 49.
49 is over.
I appear for the petitioner in 49.1 minor. for the appellant in 49.1.
Re-notify.
99,
Please, oblige.
Obliged.
50, the Narayan Bhatt,
Re-notify.
of August. Serial number 51,
It's no urgency, my lord. There is any.
Re-notify.
68, 52, Dayanand Gaur,
Please.
Re-notify.
38, 53, Vachan,
Re-notify.
88,
Oblige, my lord.
Chandrasekhar,
Notice may be ordered by, it's an on, for the on-conference, coming for the first time. Notice may be ordered and date may be fixed.
We have to see it. We'll have it next week. Let's see that. Re-notify.
22, 7. Serial number 55,
Will go along with serial number 45, your lordships, 30th of July.
Re-notify.
30th of July.
Much obliged.
66,
Re-notify.
69. No, 69. 15.
Hmm? This is the only one. You have told the councils.
Serial number 57.
Lord, I appear for the petitioner in this case. There has been an interim order from the Honorable Supreme Court from 2014. And now in March, the Honorable Supreme Court said approach the High Courts in all these matters. This is regarding extension of lease, my lord. Forest lease is extended, MMRD Act to be coterminous with that. And that is also now extended, my lord. But the interim order now granted by this Honorable Court, Lord, may kindly be extended. Any date that may be convenient to them may be fixed.
Re-notify on. Just see the, just, if you have the file.
In the course of the week, I will be filing rejoinder to the central government's order, my lord, which is impugned.
Counter.
Central government has filed, my lord. And I am filing a rejoinder to that.
Then a senior counsel for the petitioner states that rejoinder to the counter affidavit filed by the central government shall
So,
be filed during the course of the day. Interim order already granted shall continue to operate till the next date of hearing. Just give a date after 2 weeks, 3 weeks, 2 weeks.
20th of August.
Next.
Serial number 58.
Lords, I beg to appear for the petitioner, my lord. In this PIL, my lords, the respondent have sought to file their response, my lords.
And even for the very well, re-notify. You file your counter. Is appearing. Next.
18. Serial number 59.
Re-notify appear for the
For
respondent.
the petitioner, my lords, it's a fresh matter, my lords. May I request the matter to be taken on Thursday, my lords? It is coming up for the first time, my lords.
Thursday.
Of August.
Yes, you are mentioning 59, no?
59 minutes.
She wants Thursday. She wants Thursday. Give it.
First of August.
Any matters are posted in the next week by the honorable.
We'll have it next week, ma'am.
First
Yes,
week
my
of
lords.
August would be
How many are there? 60. 60. Is there any urgency?
My lords, we have challenged the notification passed by the central government, the Department of Mines and Geology, where I have purchased the iron ore in bulk, and now they have reduced the quantity, my lords. They have, that has to be looked into, my lords. Kindly have it next week, my lords, if I may request.
There.
54-7. 60, Sri Kalyana. 60,
Re-notify.
21-8, serial number 61, Ram Kumar.
Please, Your Lordship. Lordship, the notice was issued previously and it is coming after notice. The other side has to file a reply.
You are appealing?
Kindly grant us this time.
Then a counsel for the respondent seeks is allowed 4 weeks to file counter affidavit. Re-notify on.
22-8, serial number 62,
Filing the disbursement.
62.
Because matter in this case pertains to the administrative tribunal members. In respect of those members, my lord, where tenure is over, Supreme Court has directed that till fresh appointment is made, they should be continued in service. So that we have said, my lord, that that should be implemented.
We'll have it. Just
Let
give
me
it
be
after
permitted
2-3
to file
weeks.
the statement of objection.
They have to make their stand. It is not a question of.
Counsel for the respondents states that
192.
just file it in the registry.
Yes.
Shall file,
That
states
any
that
time
the
this week, my lord.
objections to the writ petition shall be filed during the course of the day.
Yes, my lord.
Give him a copy. Give them a copy. Any rejoinder to the same be filed within 2 weeks.
Lord, immediately we are ready. We don't want to any time for any rejoinder. We'll actually give some day
When a
this
counsel
week.
for the petitioner states that he does not wish to file rejoinder to the same, re-notify the petition on, just give it after 2 weeks.
Lord, Friday, my lord,
We'll just give it, we'll see it also because we'll just give you a date there.
some urgency. Otherwise, last time, my lord, when we mentioned it to the court gave today's date. That's why.
Just give next week, just give it next week.
22-7,
Next,
serial number 63. 63.
re-notify.
49, 64.
Complaint in.
Re-notify on.
9th of September, 65, fine hearing.
For respondent number
For the petitioner, my lord.
only have it, my lord. Any other day this week, there is some urgency, my lord. I appear for respondent number 4 in this.
We'll have it after to re-notify on.
Now, kindly have it next week, my lord. There is an interim order of the.
Yes, give it.
Obliged, madam.
66, Shyam
Next.
Pullen. In
Please, my lords. Re-notify.
Last.
10-9, 57,
For the appellant.
Appear for the respondent in this case, my lords.
After hearing both the parties, interim order was granted and rule was issued in this matter, my lords. It requires a hearing.
My lords, there's some urgency.
Re-notify.
There's some urgency in this matter, my lords. The learned single judge had set aside my dismissal order and my reinstatement, my lords.
That is
Some-
state.
Re-notify on. Just give it after 2-3 weeks.
13-8,
My lords, interim order may kindly be extended.
Interim
Just
order
give
if any to continue.
Much.
8. Deep Costa.
Lord, appear for the petition. Lord, there is some urgency in this matter for the very reason that learned single judge has ordered reinstatement with consequential benefits along with interest and has imposed 50,000 rupees cost, my lord. My lords, we are seeking for interim.
Has he
short-
filed any contempt?
My lords, they haven't proceeded with contempt yet. First time, but
Re-notify.
lords, next week, please, my lords, shortest date.
What is the urgency? Tell us.
My lords, they may proceed with contempt.
Contempt would be filed, notice would be issued.
Please.
Before that, we'll give you a date.
Please.
Just give a date after.
My lord, I am for respondent. This is a domestic inquiry matter where the officer after retiring on 31st May 22 dismissed on 15 July 22. And they stopped all lifeline, no pension, no medical, and they recovered 60 lakhs. And the honorable single judge came with a decision after purely on merit, not on domestic, purely on merit, they set aside all the orders. Now we are struggling for survival. And this is and the lady is a cancer patient about to undergo surgery.
Give me a short date. Just give it after.
It may be considered for in this week or at least by 25th, Honor.
At 1st of August.
Much obliged.
Obliged. Deeply obliged.
May I make a submission, Your Lordship?
Yes, ma'am.
This list serial number, list two, serial number 10 matter, contempt matter. I just inadvertently missed the call out because it was colliding with the other matter. My humble submission is they have not complied with the order or filed a compliance affidavit, and they are not even present before the court. They are not even representing properly. It's been,
Number, ma'am, item 10.
pardon, Your Lordship,
You said item 10.
item number 10, Your Lordship.
This is Manohar.
Yes, please.
Yes, what is the date given, ma'am?
19th of August.
You have given 19th August, ma'am.
May I request for a shorter date? About 1.5 crores of bill is pending to be paid by BBMP to the civil engineers who have executed several works. Now,
Yes. You are giving 19th, ma'am. In any case, a short date. Okay. Thank you. Next. Yes, call. Yeah.
This number 1, serial number 1, orders. Saravanan.
I will get it rectified by next week notes.
The office objections be rectified within 2 weeks. Re-notify on.
First, may I have this matter next Monday minutes? Next Monday minutes, if it could be.
Give your date. We'll give you a date.
5/8, sir. Number. Number 2. Marilinge
This you have
Lord,
settled.
matter, it is settled before the mediation settlement. Lord.
Just give this. This, in terms of order dated 14/6/2024, the parties were relegated to the mediation process under the aegis of the Karnataka Mediation Center, Bengaluru. Full stop. The Karnataka Mediation Center has filed its report. Has filed a memorandum of settlement entered between the parties dated, just say dated 15/6/2024. Whereby the parties have settled their interstate disputes in terms of para 3A to D. Yeah, just say, don't say para 3 in terms of this. Are the parties present here?
Parties are not.
Parties are not present.
Parties are not
Advocates are
present.
present.
Pardon?
Parties are not present, Your Lordship.
The counsel for the parties states that as stated by the parties in the memorandum of settlement,
Name.
Your name. Your.
that no, don't say as stated in the memorandum. Counsel for the party states that the party shall be bound by the terms of the settlement dated 15/6/2024. Their statement is taken on record. Full stop. Insofar as the refund of the court fee is concerned, the registry shall consider the same in accordance with law. The appeal and connected IAS, if any, are disposed of in terms of the memorandum of settlement dated 15/6/24.
Reading application, I filed a memo for conferencing.
Philip, yes, that's right. Just say before that IA, what is IA number?
IA 1/22.
1/22.
You are also part of that settlement.
No, they have filed the application to implement the necessary parties.
They were not
They have-
part of the settlement. They are not
No,
part of.
no,
the
no, 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 my lord, no, my lord.
1 of 22, the learner counsel for the applicant does not press this application. The same is dismissed as withdrawn. And the connected IAs, in view of the above order, the connected IAs have become infructuous and are disposed of as such. Just say that. How many IAs are there?
One is.
Only one.
Only one. This has been withdrawn. Completement, that's the only one. Okay, thank you. No, then last cut it. They have, we have said, the other IAs have become infructuous, just cut it.
Serial number 3, Sri Narayan Sharma.
Correspondent number 6 to 10 minutes.
Let notice be issued to respondent number 145. Returnable on.
23-9. Serial number 4.
Wait for the respondent.
For the complainant. But as per,
For the respondent 4.
is listed for orders, my lord, as per the order dated 7/12/2023, an affidavit had to be filed by the
You are
accused.
filing it, I suppose. You are filing it?
We are the contested accused number 4 to 11. Contest ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ ಯಾಕೆ ಅಂತಂದ್ರೆ ಸೇಲ್ ಡೀಡ್ 13/3/2019 ಗೆ ಅವ್ರು ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ. So we are the filing the sale deed of the 13/3/2019 and also including contempt petition have been filed in the 13/3/2019. Both
You
are.
are filing that?
Sir,
You want to file that?
fine.
Just give him a copy.
Yes, sir. Okay. For that purpose contesting of the.
Just give it copy, just take it. They say nothing. This, no, are the parties here?
Hello?
Yes. Now, is the contempt alleged against them also?
Please, my lord.
But you just ask her if she wants to file any.
So, but one thing, last time, sale deed copy has received. So this property has sold in 13/3/2019. This date also of contempt petition have been filed. Both are same date. No loco standi has been filed in the contempt petition. So that purpose, we are the contestant of the accused number 4 to 11, Your Lordship.
Who filed objections then? You are saying.
What? Yeah, I don't know, my Lordship. Okay.
Simply because saying that.
So next objection have been filed.
Affidavits were filed by other respondents, my lord.
In the last
The
occasion,
thing is
they had.
that the property was sold on the very next day.
No, this data.
On the very same day, contempt
Same
petition
date.
was filed and the person who has filed the contempt sold the property also. He has no interest over the property at all. Now, the
Including
new
application has been filed.
purchaser has not been made as a party to this proceedings also.
That purpose, we have not filed the affidavit.
You are contesting, you file your response to that.
Lord, as far as I am concerned, my lord, as far as some entries or some agreement was made, I had filed an affidavit to apologizing and the contempt could be dropped as far as.
You have filed your affidavit?
Pardon?
You have filed your affidavit?
Yes, my lord, I had filed.
Yes, she wants to file it or not? You want to file any response to the contempt petition?
No, we are the contested, Your Lordship. No
Right,
response.
that's right.
To that effect only, whether you are filing any response or only judgment is enough.
Objection.
Illa, objection is not filed, my Lordship.
You file it.
Next for date we are filing the revision.
The counsel appearing for
4 to 11.
the respondents number 4 to 11 seeks and is allowed how much time?
On the last chance next week, on 2 weeks time.
2 weeks. 2 weeks.
Very well.
List the petition for framing of charge,
Objection.
for hearing on the charge
Good.
on the next date of hearing.
29th August,
Obliged.
serial number 5, Shri Sadashivaya.
My lords, in this matter, I filed an application for recalling the order, my lords, wherein the appeal came to be dismissed for non-payment of court fees. Accordingly, I paid the court fees, my lord, and application is filed.
When was it dismissed? 2/11/23?
2/11/23, my lords.
These are two applications filed for seeking condonation of 2 days delay in filing the recalling application. And an application for recalling of order dated 2/11/23. By noting the contents of the affidavits in support of the application, the order dated 2/11/23. Is recalled. The delay of 2 days in filing the recall application is condoned, and the order dated 2/11/23 is recalled. Let notice be issued to the respondents. Applications disposed of, let notice be issued to the respondents.
1st of October.
Grateful, my lords.
Number 6. Joseph.
For the applying, my lord.
Yes.
Plaintiff's appeal in a suit for partition, by which a part of, there are 4 properties. Suit for partition was decreed in respect of 3 properties. In respect of first property, the suit was not, or dismissed by holding, because that property was sold in favor of defendant number 11 purchaser, by holding that sale was for joint family necessity. Therefore, appeal. If my lords can take 355, I'll start with the.
You are ready to argue?
I'm ready to argue.
Just 1 minute. Ma'am, you are ready?
Please, my lords.
Yeah, we'll just pass over.
Yes.
We'll attend to some other.
Pardon?
We'll attend to some other first round and get back. Please.
No, we don't have a big list. We'll just come back possibly in 10 minutes.
Please, madam, then I'll wait minutes.
I appear for the appellants, my lord. Let's compromise talks are going on, my lord. Some 2 weeks time may be granted. We'll finalize the terms.
Is item 7,
And we get
counsel for the appellant seeks adjournment as according to him, the the parties are exploring settlement.
Yes, ma'am.
Adjourn to.
Obliged. 7.
Number 8.
Respondent, my lord. This is the matter in which the reference has been challenged by the management, my lord.
That's right. Where is Mr. Raghavan?
My lord, I believe he is not available today, but his colleague had informed me that they are going to seek an accommodation. But perhaps I might be permitted to finish my arguments and then.
That's right. Let's see. We'll pass it over. Let them come.
My lord, my colleague is present.
We will hear her.
Please, ma'am.
Let her complete it.
Please.
But before that, there is one matter which we are going to hear it. Thereafter, we'll take it up.
Please, ma'am.
But this would be only before lunch because after lunch, we have kept some matters.
Please, ma'am.
Nine. Govindraj.
Apologize.
Respondent number 4 in this
My lord,
Yes,
I apologize. I could not file the synopsis. It is ready. My lord.
you file it.
I will answer.
You also counsel for the party. Yes. Counsel for the parties to file their bills. Along with the judgments they want to rely upon. Within,
I appear for R4 in this.
within 4 weeks. list
R1
on-
and 2, R3. Standing counsel.
After 4 weeks. leave.
Nine.
Lord, there was an interim order which may be continued.
Interim order. What is the interim order?
Lord, the
The
proceedings of
stay of the order.
Yes.
Proceedings before the third respondent commission is stayed.
Interim order, if any, to continue till the next date of hearing. Further arguments, no? Yes. Pass here.
Till number 6, passed over matter.
Brother, if you have objection, you can take it both up. Government order.
Both codes are here.
Ma'am, is it scanned? Scanned copy?
I have filed a paper book. No document is disputed, therefore.
Pardon?
No document is disputed per se. Therefore, book can be looked into.
This would suffice.
Yes.
Yes.
My lord can take, the judgment is at page 355. I am just showing the genealogical tree, which is there in English. The genealogical tree filed by parties is in Kannada. The trial court has reproduced genealogical tree in English. It's at ink page number 359. Judgment starts at 355. Cast title is there. 359 is the genealogical tree. Ma'am. Internal page number 5 of the judgment. May please. It is an admitted fact. The properties were originally belonging to Pambe Gowda. He partitioned the property long back between his two sons Male Gowda and adopted son Kenche Gowda. Now, the dispute is not in respect of properties of Kenche Gowda. The dispute is in respect of properties allotted to Male Gowda. No, my lord. Male Gowda's daughter's children have filed a suit for partition. If my lord sees in the genealogical tree, bottommost line, Jayalakshmi P2, Mahadevu P3, Rajamma P4, Ratnamma P is plaintiff, my lord. Ratnamma P5, Nanjappa Ramesh. And my lord, in the second line above the arrow, Puttatayamma P1. Now, Puttatayamma was daughter of Malegoda. These P2 to P7 are children of Shivaramma, who was a daughter of Malegoda. Nagamma P8 is a daughter of Malegoda. They filed a suit for partition against defend number 1, my lord, Siddhamma, in the top first arrow after Malegoda. Malegoda is dead, his wife, she is mother. She is D1. Then, my lord, if your lordships comes to 3 line below, Maramma's children Nagaratnamma, Mahadevi, Mallikarjuna, D2, D3, D4. They are defendants. Then the daughters of predeceased daughter. Then Chikkannemma D5, Mallamma D6. My lord, next is important. Defend number 7, he is a son. He is Yam Mahadevu, last but one arrow, my lord. He is a son. Then Mahadev's children Sandeep and Shilpa are D9 and D10. Mahadev's wife Bharati is D8. D11 is the purchaser of the property.
D11.
Yes, my lord. D11, now during the pendency date, his LRs are brought on record. D11 is the only contesting party in this suit. Now, my lord, a suit for partition was filed. There are 4 scheduled properties, A, B, C, and D. A scheduled property was sold by defend number 1, defend number 7, defend number 8, 9, and 10 in favor of defend number 11.
Okay.
Now, in the trial court, the suit is filed saying that the properties belong to Ambegoda. It was partitioned. Malegoda got these properties. Ambegoda's properties are not involved. Suit was filed. They first contested the case saying that no, these were properties allotted to Ambegoda. But trial court has negatived the contention, as held that the properties belonging to Malegoda. There is no cross appeal filed against that anyways.
Come again, what did you say?
My lord, what happened was, in the suit, my case was that in a oral partition, long back, all the properties of family were partitioned between Malegoda and Kenchegoda. Kenchegoda's properties are not subject matter of the litigation. And I am seeking partition in respect of Malegoda's properties. Defend number 11 raised one contention that item
was the purchaser.
Item number 1 of the plain schedule, survey number 77/1, was a property allotted to Kenchegoda only. Kenchegoda had no children. He had transferred khata of the property in favor of defend number 7, and that they have purchased the property. They have said so. There is no proof. Trial court has.
Is he a purchaser with regard to other properties also?
No.
Only this property?
Yes, ma'am. Only item number 1.
So we are concerned with one property
Yes,
only, scheduled property 1.
Correct.
Now, that's only one property. What is the description of the property?
My lord, if my lord can take the decree.
Land bearing number, survey number 77.
77/1, correct, my lord.
So now only thing is, he says this property is not related to concerning Malegowda, it concerning Kenchegowda. Okay. And he doesn't have children. How did he, who sold this property D7?
What they say is the khata of the property was changed by Kenchegoda in favor of defend number 7, and therefore it is defend number 7 absolute property. My lord, it may be academical, may not be too much of concern. Reason is trial court has negative this contention. Trial court has held that the property was the property of Malegoda.
Acha, there is a finding there.
There's a finding.
Oh.
Now, what the trial court does is, trial court says, this sale is in the interest of, is for the benefit of joint family, and therefore the suit is dismissed insofar as item number 1 is concerned, my lord. Therefore, if I can persuade my lord, it's a short point that is involved, my lord.
That's right. Now tell us.
Yes, my lord.
You are plaintiff number 1?
All the plaintiffs.
All plaintiffs have come. Now, where, how does the property devolve now, in whose favor?
My lord. property, if your lordships can take the genealogical tree,
Yes.
property in partition went to Malegoda. Our case is that we are all entitled for a share in that. Defend number 7, along with defend number 1, 8, 9, and 10, sold it in favor of defend number 11 by showing only that he, his wife, his children are members of family. They are only entitled for it. And the property which was worth around 63 lakh rupees is shown to have sold for 6 lakh rupees. What the trial court does is, in the plaint he says, in the sale deed there is a recital. Recital is that I have borrowed a loan of 2 lakh rupees. And to discharge the loan, he says he has sold the property. Trial court gives 2 reasons. It says, one, to discharge the loan, he has sold the property, and he has, after the sale, performed his daughter's marriage, and therefore that sale is for joint family necessity. Point involved is short, my lord. All I am saying is, if he has not.
Let's see the issue frame.
Yes.
And let's see the finding.
Yes, my lord. My lord can go to page number 366. On the basis of the above pleadings, the following issues are framed for trial. 1. Whether the plaintiffs proved that themselves, defendant 1 to 4 to 10 are members of joint family and suit properties are ancestral joint family properties of all. 2. Whether alienation of suit A property by defendants 1, 7 to 10 in favor of defendant number 11 is illegal and not binding on them. 3. Whether the plaintiffs prove that defendant number 3 was given in adoption as such is not a member of the joint family. 4. Third issue may not arise. I have not challenged that aspect.
Although primarily we concern with 1 and 2.
Yes. No, my lord, reasoning is that
4 is an issue or a non-issue. 4.
it cannot be an issue, my lord. Because in a specific performance suit, he can claim to be bona fide purchaser file value without notice. In a partition suit, it may not be of any help.
Yes.
Now, my lord, paragraph number 15 at 367, discussion start. Paragraph number 16 at page 368. I'll just read this portion, my lord. It's a short judgment. In this case, on perusal of pleadings and available evidence, the dispute only in respect of suit A schedule property, and it is between the plaintiffs and purchaser of suit schedule A property, that is defendant number 11. Defendant 1 to 10 have not filed written statement nor led any evidence. It is a case of the plaintiffs that about 50 years ago, there was an oral partition among Malegoda and Kenchegoda.
We'll just interrupt you. Only 11 has only contested the suit.
Yes, ma'am.
The purchaser.
Yes, ma'am. And in the said partition, suit schedule A to D properties were given to the share of Malegoda, that is father of plaintiff number 1. Defendant number 11 has admitted the said oral partition, but contended that in the said partition, the suit schedule A property was given to the share of Kenchegoda. After the death of Kenchegoda, the said property was mutated in the name of his wife Kempamma. Thereafter, Kempamma transferred the said property in the year 1997 in the name of defendant number 7, who sold the same to defendant number 11. Hence, social property is not the ancestral property of the plaintiffs. Plaintiff number 3 has filed his affidavit in lieu of his examination in chief, reiterating the averments of the plaint. PW2 is wife of Kenchegoda.
Tell us one thing. Now, defendant number 7 has sold it to 11. How is defendant number 7 asserting a right on the property? How is he asserting a right that he has a right to sell it?
My lord, defendant number 11 says in the written statement that he represented to them that he, his wife, his daughters, and his mother are only entitled for this property and sold it.
That's all. They represented, they are entitled to. Okay.
My lord can see the written statement. It
And
is
7 doesn't file any written statement.
but my lord, what is interesting here is this property is sold in March 2006. The property was notified for acquisition in 2005 ending, and in October 2016, this is 3 acre 10 gulta sold for 6 lakh rupees. October 2016, compensation agreed to be paid is 21 lakh per acre, which comes to about 66 lakh or 67 lakh rupees.
Who got the compensation? It's
Uh,
lying, the money is lying there.
It is lying there, my lord.
We have departed of this all court. We have departed of this all court pursuant direction of this all court.
No, my lord. Therefore, as I said, the only question will be, substantial question is, if a member of the family claiming to be Karta does not disclose the existence of joint family or sisters and sells the property, can still the sale by him by held to be the profit sale for the payment of, benefit of the joint family. Because my lord, if he had disclosed that it was for the benefit of daughters also, perhaps I had a bigger task. I had to show that there was animosity, all that I had to say. Here, it is a simple case. Admittedly, he has not disclosed that we are daughters, that we are there. Without our notice, it is sold. The purchaser has not done due diligence and is a property in a village, my lord. Enquiry would not have been so difficult. And one more suspicious circumstance, as I said, is within 6 or 7 months from the date of the sale, state KADB has paid compensation to the extent of about more than 10 times the value of this property. Therefore, I am saying because of these two aspects, one, that sale is by suppressing the existence of the joint family itself. Two, and it is their case, my lord, it's not their case. And sale consideration is also their case. If your lordships can take the written statement for 1 minute, I'll just show. Or I will complete reading of this, my lord, so that can I continue reading, my lord?
But 11 accepts there is a partition.
He accepts that there is originally a partition.
Originally a partition means?
Between
There. Oh.
correct. Hombegowda, Kenchegowda and Malegowda. My lord, after the death of Kenchegowda, the said property, I'll read para 17. Plaintiff number 3 has filed his affidavit in lieu of his examination chief, reiterating the averments made of averments of the plaintiff. PW2 is wife of Kenchegowda and PW3 is daughter of Kenchegowda. Both of them have deposed before the court stating that Kenchegowda was the foster son of Propositor Sombegowda. There was an oral partition between Malegowda and Kenchegowda during the lifetime of Propositor Sombegowda. In the said partition, plaintiff A to D schedule properties were given to the share of Malegowda. Properties equal to the suit schedule A to D were given to the share of Kenchegowda. Suit schedule A property was wrongly mutated in the name of Kenchegowda. Hence, this PW2 is the wife of Kenchegowda, has transferred the suit A property in the name of defendant number 7, who is son of Malegowda under MR number 43 of 96-97. In fact, this is very loose usage of my lord. MR is mutation, change of khata. It cannot amount to transfer of property. Hence, the suit schedule A to D properties are ancestral joint family properties of plaintiffs and defendant 1 to 10. PW2 in the cross-examination admitted that in the year 1989 to 92, suit A property was standing in the name of her husband Kenchegowda. After his death in the year 92, the said property transferred in her name. PW2 further admitted she has transferred suit schedule property in the name of defendant number 7. PW2 denied that since suit A property is transferred from her name to the name of defendant number 7, hence it is not the ancestral property of plaintiffs and defendant 1 to 10. Admittedly, Kenchegowda was the foster son of Propositor Sombegowda. Admittedly, there was an oral partition between the natural son by name Malegowda and foster son by name Kenchegowda about 50 years ago during the lifetime of Propositor Sombegowda. PW2 and 3 are none other than wife and daughter of Kenchegowda. In the light of evidence of PW2 and PW3, the case of defendant number 11 that the suit issue property is not the ancestral property of the plaintiffs and defendant number 1 to 10 cannot be believed. It is not the case of the plaintiff. The defendant number 7 who sold the suit property to defendant number 11 was addicted to any bad habits and he was acting against the interest of the joint family. Admittedly, defendant number 7 is the only male member after the death of Malegowda in the joint family consisting of plaintiffs and defendant number 1 to 10. In the plaint itself, the plaintiffs have stated that after the sale of suit issued property by defendant number 7, a loan of rupees 2 lakh raised by him from Srikanteshwara Prathamika Sanna Kaigarika Gramina Abhivruddhi Bank Niyamita Nanjangud is repaid. The said loan was obtained by mortgaging the social property. It is stated that the said loan is not utilized for the welfare of joint family. PW1 in a cross-examination stated that she do not know that the loan raised by defendant number 7 from the above bank is for the necessity of the joint family. PW1 admitted that after the sale of suit issued property, defendant number 1 has performed the marriage of his daughter in Police Bhavan at Mysore. PW2 in a cross-examination has clearly stated that defendant number 7 raised a loan for marriage of his daughter and the said loan is repaid out of sale consideration. PW3 in a cross-examination stated that defendant number 7 was managing the family affairs of her uncle Malegoda. PW1 to 3 have admitted that defendant number 7 is the only male member of family after the demise of Malegoda. Exhibit D15 is the reconveyance of mortgage. On perusal of which it can be seen that after the sale of suit schedule A property, defendant number 7 has repaid the loan of rupees 2 lakh raised from the PLD Bank Nanjangud. On perusal of exhibit P14 certified copy of the sale deed, wherein it is mentioned that these defendant 1 to 10 have executed sale deed in favor of defendant number 11 in respect of suit schedule A property for the repayment of loan raised from PLD Bank and for the welfare of minor children and to purchase other immovable properties. All this oral documentary evidence shows that alienation of suit A schedule property by defendant number 7 is in the capacity of Karta of joint family and for the repayment of loan of PLD Bank and other family necessities. This is where I said, my lord, it can be for the benefit of joint family which is shown in the sale deed. If they do not even disclose the existence of any other joint family, can it be even presumed that it is for the benefit of the joint family, the existence of which is not even shown?
Yes.
PW1 to 3 have clearly admitted that after the sale of this suit schedule A property, defendant number 7 has performed the marriage of his daughter. Spending money for marriage of daughter by father is considered as family necessity. This is a bit misconceived, my lord. Reason is, if the sale was done saying that it is for the sale of a joint family member, I am selling the property. It is sale done for joint family necessity. You first sell the property, use a portion of it for some purpose and say, therefore, it was sold for joint family necessity is perhaps not permissible in law. That approach cannot be. Admittedly, defendant number 7 has repaid the loan of PLD Bank after sale of Schedule A property. Hence, repayment of the loan raised for the family necessity by the sale of Schedule A property is also considered as family necessity. Hence, the acts done by Karta of family binds the members of joint family. Hence, the sale deed executed by defendant number 7, his mother, defendant number 1, and his wife and children binds the other members also. In this case, P14 is a genealogical tree issued by revenue inspector on the information and request of defendant number 7. This is also court records. On perusal of this, it is mentioned that defendant numbers 1 to 7 are only 1 and 7 are only legal heirs of Malegoda. Defendant number 11 is the resident of Anekal of Bangalore district. Hence, he is not supposed to know all the details of family members of defendant 1 to 7 when the genealogical tree as per exhibit P14 is produced. This is issued by competent authority. This approach again is a bit misconceived, my lord, because the law is, it was for the purchaser to inquire. And this is a village. It's not like a sale deed happening in Bangalore where it cannot be known.
Tell us one thing, if ultimately it is held that the property is basically joint family property, then how that will have a bearing insofar as the sale of the property to the defendant number 11? How will that affect it? Because ultimately, at least what one can see is the property belonged to this hodgepodge and it required to be partitioned.
Yes,
whatever the share of the in the property of all these people, the defendants and the plaintiff, that share or the value of that share need to be given to them.
Yes, my lord. Correct.
That's sum and substance.
Yes, my lord. Correct.
Will that have any bearing insofar as the sale to defendant number 11?
My lord, the sale cannot be binding insofar as we are concerned.
Okay. Okay. So what follows? If it is not binding, what will follow?
My lord, two things. One, they have paid a consideration. They can, in the return statement, they have pleaded, additional return statement, defendant number 11 has pleaded. They can say, see, I have paid 6 lakh rupees. The time value of money is this much. And they can go after the share of defendant number 7 and defendant number 1, who are property to sale deed in BCD properties also. And they say, therefore, to this extent, we are entitled for our value, or they can recover it from them. I am not saying that
Yes, one. Yes.
My lord, if my lord can see additional return statement filed by defendant 1 to 3, they have also pleaded the same thing. It's at page number 54.
It's down to only one question, whether the sale by defendant number 7 in favor of defendant number 11 was for family necessity or not.
Can it be said to be for family necessity when the sale is done without even disclosing the existence of system?
About the sale. Whether sale has taken place or not is not our concern, because ultimately it is to be decided in the valuation, etc. is to be there in the final degree proceedings, not now. So the question is whether this A scheduled property was sold to the defendant number 1 for family necessity or not.
Yes, ma'am.
And regarding the inter-se partition between you, that is the plaintiff and the defendant number 1 to 10, that is not in dispute.
I agree.
And because defendant number 1 is contesting defendant number 7 and others, they have not filed any income statement denying that there is no such joint family.
Correct.
If at all a question is raised by the defendant number 11 that there was no such joint family, then it is for the defendant number 11 to prove it.
They have raised it. In fact, therefore, they admitted that Kenchegoda was
they do not say that there was partition between the different plaintiff and different number 1 to 10.
No, my lord, there was never partition between
They say that Kenchegowda had Kenchegowda
Malegoda.
had given the property
Malegoda.
to- No, Kenchegowda had given the property by way of mutation entry.
My lord,
The defendant number 7.
no, my lord, two things. Original, I am also not saying there is partition between main defendants. It is between fathers, Malegoda and Kenchegowda, that they also admit.
That they admit.
That they admit.
This property had fallen to the share of Kenchegowda, a scheduled property.
Malegoda. Kenchegowda's wife herself came to witness box and gave evidence to that effect.
Saying that it fell in the share of Malegaon.
Correct. Kenchegowda's wife and Kenchegowda's daughter, both of them, PW2 and PW3, and trial court has therefore held it is joint family property.
Mutation entry.
Mutation entry, she says, what happened was, in the partition, it fell into share of, these properties fell into share of Malegoda, but mutation from up to 1992 was in the name of Kenchegowda only. Therefore, on her demise, she allowed transfer of mutation in the name of defendant number 7. And it is nobody's case that she has sold it to defendant number 7 or that there is a sale deed, nothing. No pleading, no evidence, nothing on that.
No. Defendant number 11, whether they admit that it had fallen to the share of Malegoda.
No, my lord, what they say is,
It had fallen.
they say it, no, my lord, there it's a bit cryptic in the sense, it's not clear. They say it fell to share of Kenchegowda. Kenchegowda gave it to defendant number 7. Now, if Kenchegowda gives it to defendant number 7, how it is to be given, how it was given, and that
That's
there,
a different matter.
and therefore they have purchased.
Deed, will, etc., or a mutation entry, that is the second matter. And if it is a
No, my lord,
mutation entry,
even-
it is not a valid transfer. that
No,
is
my lord,
different.
in that case also, what happens is, if their case is that Kenchegowda and his wife have no children, therefore they have given it to him.
I'm asking this question only to ascertain what is the contention of the defendant number 11 in respect of a scheduled property.
Two contentions.
Which had passed on in the name of the defendant number 7.
They say it was transferred by Kenchegowda to defendant number 7.
In that event, they cannot say that there was a partition between the plaintiff and the defendant number 1 to 7. Or it was sold for the family, joint family
Correct,
necessity.
correct. They are inherently,
That is why I am asking this.
they are mutually restrictive, correct.
That's right.
Where? So, purpose of my question is that if the property had flown through Malegoda, then they could have contended that the family necessity was there and therefore this defendant number 7 Mahadevu transferred the property to us. For that, they should admit that the property has devolved upon this branch of Malegoda. If they had contended that Kenchegowda was the owner and through Kenchegowda it came to this branch or the defendant number 7 directly in whatever manner it may be, then they cannot contend that there was necessity of family necessity so far as the plaintiffs are concerned, because plaintiffs are now concerned with that branch of Mahadev.
Correct, ma'am.
So that is what I wanted to.
My lord, I will go a step further. In fact, even that argument also gets defeated. Reason is, if their case is that Kenchegowda and his wife have no children, it is transferred to Mahadevu. They don't say how and all. If it has devolved on Mahadevu, even in that case, I will say class 2 legal heirs perhaps still I will be entitled for it. But this besides point, my lord, I cannot get into it because there is no pleading evidence. The case will go on a tangent. I cannot get into it. I cannot even argue that position. My lord, therefore, these two aspects.
So one is clear that it devolved in the branch of Malegaon.
Yes, ma'am.
So everyone has some share.
And the sale is highly suspicious because in the written statement, they say this, it was in October 2006, my lord can take the written statement filed by the defendant number 11, my lord.
Let's see the ground on which it has been rejected.
Yes, my lord. Paragraph number 19, it is held a joint family property, my lord. Para 20 to 23. Para 23 particularly, my lord. Is 72. Ide paper ఒకటి. And my lord, finding in para 23 is also misconceived. Reason is they say after the sale performed a marriage of daughter and therefore joint family. If sale deed recitals are seen, my lord, sale deed is exhibit P14 at page number 152. I'm sorry, my lord, it's in Kannada. If it's permissible, I will read it. It says in page 153 that it is sold for clearance of the loan in PLD bank and his maintenance of his minor children and to purchase some other property. There is no mention of daughter's marriage.
What does it say? How do you contest this finding
Yes, ma'am.
on family necessity?
My lord, that's what I'm pointing out, my lord.
That's the only issue.
Yes, my lord. Family, if in the sale deed, therefore I'm saying, my lord, in the sale deed executed, it is mentioned that defendant number 7, 8, 9, and 10 and defendant number 1 are the family members. Existence of the sisters is not shown. I am saying it can be argued or presumed that it can be for the family necessity of the family shown in the sale deed. If existence of the family itself is not shown, if sisters being alive itself is suppressed in the sale deed, to say that this, that suppression.
Tell us whether a wife can also be part of the sale deed of defendant number 7.
Could not, need not have been, my lord.
Even the child also, it could not have been.
Yes, my lord. Child perhaps could have been, my lord, if it's joint family property, because from birth they will get a right. But definitely wife need not have been a part. And as I said, my lord, a property worth 65 lakh rupees from the records is said to be sold at 6 lakh rupees, and both are there in the return statement of the defendant only.
7 to 10.
D1 7 to 10.
7 to 10.
Huh.
Sold the property.
Correct. 1 is mother, 7 is son, and P14 is the sale deed. If my lord can see para 3 of the return statement once, it's at page number 34. Please, madam. The allegations contained in para 3 of the plaint relating to G3 of deceased Hombegoda and Sannamma is not within knowledge of defendant, and hence specifically denied as false, and the plaintiffs are put to strict proof of same. Next, my lord, important. In fact, at the time of purchase of land bearing survey number 77/1 measuring 3 acre 10 guntas of Tandavpura village, the 7 defendant Mahadeva has given G3 of deceased Malegoda and Maestri Malegoda issued by competent authority, and in that G3, this defendant finds the name of first defendant and defendant 7 to 10 as survival members of deceased Malegoda or Maestri Malegoda. As the G3 was issued by competent authority, there was no reasons for the defendant to suspect the correctness of the entry in the above said G3. My lord, it is a bit misconceived because genealogical tree is not issued by authority. These people go make declaration before the authority, and therefore it is issued. That's all. And my lord, in the same written statement, at page number 41, my lord. Page number 41, my lord, 3 lines from the part. Did act of 7 defendant in relating to getting false G3 of Malegoda of Maestri Malegoda in collusion with the governing department of officials amounts to criminal offense. In sort of they impliedly admit, my lord. This defendant reserves his right to prosecute the same in competent criminal court of law. It is submitted that by the defendant that in the year on 31/10/2006, the government of Karnataka through preliminary notification has acquired an extent of 324 acres 7 guntas of land which are situated at Thandavpura and Adakanali villages, and this defendant's land bearing 77/1 of Thandavpura was included in the above said notification. And finally, through gazette notification dated so and so, the government of Karnataka issued final notification through which this defendant's land was acquired, and the government of Karnataka has fixed a sum of rupees 21 lakh. As my lord knows, the fixation of the consideration is as on the date of preliminary notification, which was on 31st of October. That's what I said. 21 lakh per acre, my lord, not even for the whole property. 3 acre, 10 guntas. And why I am emphasizing this, my lord, Honorable Supreme Court has held that there are various case laws, my lord. I am relying only on one judgment, where Honorable Supreme Court says a karta can sell for joint family necessity. One, in the facts of that case, court says if it is for his own benefit or his own loan, it is not for joint family necessity, and sale consideration is shown to be very less, and for that reason also sale is set aside, my lord. It is the judgment of the, my lord.
Okay, let's hear them also.
One last aspect, my lord. Honorable Supreme Court has quoted a judgment of Madras, Allahabad High Court to say if the sale is for grossly inadequate consideration. For that reason also, the sale is liable to be set aside. I'm giving the judgment, my lord. I'm giving a copy, my lord. Sir. Paragraph 54 can be seen to understand fact and 63 thereafter, my lord. Paragraph 54.
Where did the money go after sale?
No idea, madam. They say one he discharged a loan of 2 lakh rupees to PLD bank. Rest is not known. There is no evidence.
Okay,
There is some
let's-
statement that he performed his daughter's marriage.
Which para you are relying?
Para 54, my lord, on a slightly different aspect, on sale consideration aspect.
Yes.
From the evidence discussed above, both oral and documentary and circumstantial, we are in agreement with the trial court that the sale deed dated August 22, 1955 is true and it is supported by consideration, but only in part, and that even the recited consideration in the sale deed is thoroughly inadequate, that the sale deed was executed only nominally for a collateral purpose and with view to stave off creditors with express understanding that properties would be reconveyed to the vendors after pressure of creditors and subdued. The rest I am not considered, my lord. Concerned, my lord. Now, my lord can go to last paragraph, that is paragraph number 63, my lord. I read it only to show that the finding is there, that consideration is inadequate. Para 63, there is, however, another condition which must be satisfied before the son could be held liable, that the father or the manager acted like a prudent man and did not sacrifice the property for inadequate consideration. In Dudnath versus Satnarayan Ram, a full bench of the Allahabad High Court observed, in order to uphold an alienation of a joint Hindu family property by the father or the manager, it is not only necessary to prove that there was legal necessity, but also that the father or the manager acted like a prudent man and did not sacrifice the property for inadequate consideration. A Hindu father or manager of joint family is expected to act prudently. However great the necessity may be, if the joint family property is sacrificed for an inadequate consideration, it would be a highly imprudent transaction and it would be a case where, though for necessity, father or the guardian has not acted for the benefit of the estate or the members of the joint Hindu family. The father or the manager is not the sole owner of the property. In fact, until the partition takes place, even his share does not stand demarcated. The ownership vests in all the co-partners taken together as a unit. The father and the manager therefore only represent the co-partners. Consequently, the co-partners stand bound by the act of father or manager family only to the extent the act is prudent or for the benefit of co-partner or estate. Last sentence, my lord. This is what Supreme Court, Honorable Supreme Court says. In the instant case, on the finding arrived at that the consideration for sale deed was thoroughly inadequate, the sale cannot be upheld.
Yes, ma'am, we'll hear you.
No problem. Thank you. Wait, please. Raj.
Yes.
Yes, we represent D11. He died during the pendency of the proceedings. And then now before your lordships, in the trial court itself, they were at 11A, B and C. Your lordship will get it at page 4 of the paper book. Now, my lords, in the appeal, there, because 3 LRs were there, they are arrayed as 11, 12 and 30. So respondents 11, 12 and 30 represent the branch of original defendant 11, who is the only contesting defendant before the trial.
11, 12, 13.
11, 12, 30. Please. One submission is that the sale was of the year 2006. The suit is filed in 2013. That's one thing. Second is.
But was any issue on this?
Fair. No,
It's a
I'm just,
partition.
I'm not on that particularly. 2006 is the sale. 6th month of 2006 is the sale. 10th month is the date of notification. So the question here is, what is the amount that is fixed that looks very lucrative or very attractive for the other person to move? And the logic behind fixing the compensation is entirely different. That cannot be construed as an undervaluation of the property as on the date of the sale deed is my first submission before your lordship. The logic behind quantifying as to what should be the compensation given to the owner of the land, it's 66 lakh rupees. Assume 21 into 3 means it must be around 66 lakhs, 63 lakhs. Whereas they sold it for 6 lakh rupees. What would be the logic? Today, if we take it from the buyer's perspective, if I had invested that 6 lakh rupees instead of on that property, probably on some other property, then Today, I wouldn't have even lost that land. Today, I have lost the land also, and my land would have fetched me 2 crore rupees also. So this is something which cannot be considered at all, is my humble submission, my lords. The decision that my learned friend has placed before kind self is one decision where if it is illegal or sold for some other purposes, then it is something different. Here it was sold for,
Who got the compensation amount is lying in the court,
please, my lords, it's,
but you have a claim on that in view of this.
we have a legitimate claim on that.
Received 50% by virtue of the order passed this sound.
We have received 50%
Of the compensation.
of the compensation. Already we have received.
The 50% is deposited in the court.
Please, madam, it's still lying with us. And second thing is the 12th.
When did you receive, just sorry to interrupt you, when did you receive that 50% compensation?
Post filing of this appeal.
Or is it before filing of the suit?
I'm
No,
appealing for the land action officer. Lord. I'm appealing for the land action officer.
KIDP.
Lord, 21 lakhs is not the market value, my lord. No, it's by way of consent of the parties will determine that includes market value, solatium, 12%, other all components. That is not the market value at all other than that day. That was determined in 2013, my lord, by way of consciousness between the parties. Because they were the owners, they agreed. Almost all the people are agreed to receive the compensation by way of determination, consent, my lord. Section 29 of the KID Act permits for payment of compensation by way of agreement. As that, my lord, it was determined at 21 lakhs. That is not actual market value. That is
the consented amount.
yes, it includes market value, solution, 12%, other all components. That's
The
my
reason
submission.
for that was.
Then, my lord, madam,
So we asked who, when did you pay the 50%?
yes, my lord, just a minute. 13 lakh 12,700 was paid in 2015, my lord.
Pardon?
The 13 lakhs 12,500 was paid 12/1/2015.
Oh.
Ocean. Then, my lord, they filed an application here because by that time we came to know appeal is pending. We declined to disperse the remaining amount. Therefore, they made an application here for disarmal court. Disarmal court directed us to depart the balance amount. 52 lakhs 505,000.
This court directed you to
Depart the balance, entire balance amount.
deposit.
Yes, my lord. That is order dated 24/8/2020, my lord.
24/8,
2020.
2021.
Yes, my lord. Pursuant to that, my lord, we have departed 52 lakhs 50,000 before the Disarmal Court on 4/9/2020.
52 lakhs.
Yes, my lord, 52 lakhs
50,000.
50,000 on 4/9/2020. Then, my lord, Disarmal Court on the same day, 24/8/2020, was ordered to release 18 lakhs 50,000 in favor of these respondents. Disarmal Court permitted to withdraw that amount.
By the defendant level,
Yes,
in favor by defendant.
by these purchasers. So, my lord, balance is available before Disarmal Court is 34 lakhs with interest, accrued interest by the bank. 34 lakhs is available before Disarmal Court.
That takes care of complete compensation?
Yes, my lord.
Please.
My lord, in all, my lord, these people are paid 31 lakhs 62,500. See, 31 lakhs 62,500 they received so far.
31 lakhs.
31 lakhs 62,500. Earlier paid and subsequent paid by Disarmal Court.
Dependable level.
ಹೌದು
Yes.
ಎಲ್ಲ
Almost 50%.
50%.
By the defendant number level.
Yes, ma'am, purchaser.
That much of the amount is paid to them.
The
The
defendant
remaining
number
amount
level.
is spent.
Remaining amount is about 34 lakhs lying in the register of
But you,
Disarmal Court.
Acha, you said 18 lakhs only released.
18 lakhs were released by virtue of Disarmal Court. Before the 13 lakhs was paid.
Okay.
That's
All set together.
set together, I am saying, not
Approximately
giving a
50%.
all total.
That was paid by you only,
No, before that, before paid.
before that.
Yes,
Okay,
that's, I was stated.
very well. Now, what,
Yes, I was about to make some submissions here. The question whether it belonged to, considering genealogical tree. That may not be gone into now for two reasons, my lords. One is that we have not challenged that. It is their own case that it's a joint family property and we are all members of the joint family. So that question, because they consider themselves as joint family members, and then we haven't contested that particular part of the finding of the court below. So that question may not be here, that need not have to be considered is my humble submission, number one. Second is that in the very chief examination of Kenchegoda's wife, she herself said that this particular property was wrongly mutated in my name. Then after knowing that during the time of my husband's brother himself, I agreed, and then the kata and everything got transferred in the name of the D1, first defendant, D7 is what she says. Just 2 lines of this PW2's.
But the plaintiffs can challenge that finding. Insofar as the finding that was in the interest of the joint family, the land was sold.
Plaintiffs can challenge. I'm not under. I bow down to your lordship. I'm not under. I'm just telling that whether it fell to this branch or that branch, Kumbegoda's 2 branches, that's no more a question to be considered.
That's right.
And for your lordship's kind attention, I request your lordship to kindly see page 1191, para 3 of paper book.
Possibly he is also not contesting that. You are not contesting.
No. It's their own.
It is favorable to me, my lord. That's what
Huh?
learned senior is saying. The finding that the property is a giant family property has not been challenged by them, and therefore learned senior is saying that need not be gone into because they are not contesting it. It's favorable to me.
May I read it in Kannada?
Yes.
Dava A schedule ಸೊತ್ತಿನ ಖಾತೆಯು ತಪ್ಪಾಗಿ ನನ್ನ ಯಜಮಾನರಾದ ಕೆಂಚೇಗೌಡ ಪಂಪ ಕೆಂಚರವರ ಹೆಸರಿಗೆ ದಾಖಲಾಗಿದ್ದು ನಂತರ ನನ್ನ ಹೆಸರಿಗೆ ದಾಖಲಾಗಿರುತ್ತೆ. ಸದರಿ ವಿಚಾರ ನನ್ನ ಭಾವನವರಾದ ಮಾಲೇಗೌಡ ಗಮನಕ್ಕೆ ಬಂದ ನಂತರ ಅವರ ಮೌಖಿಕ ಸೂಚನೆಯ ಮೇರೆಗೆ ನಾನು ಎ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ಖಾತೆಯನ್ನು -MR ಮೂಲಕ ಅವರ ಮಗನಾದ ಈ ದಾವೆಯ 7ನೇ ಪ್ರತಿಯಾದ ಮಹದೇವ ಹೆಸರಿಗೆ ಬದಲಾಯಿಸಿದೆ. So even she has not though she has stepped into the witness box, she has not claimed any independent right over this property. So that question need not have to be gone into is my second submission. One is with regard to the valuation of the property. Second is with regard to this question, if at all your lordships want to go through this particular question, then my answer is at para 3 of Kenchegoda's wife, who is PW2. There are witness has. Now your lordship may kindly see. I request your lordships to see the plaint for a minute. Admittedly, all the daughters are married. They are all staying in different places. That's one thing. Kindly see para 5 of the plaint at page 10 of the paper. That the plaint C and D schedule properties were initially vacant sites. After demise of the said Malegoda, the plaintiffs and defendant 1 to 10 out of the income derived from plaint A schedule property. Kindly see minutes. Out of the income derived from plaint A schedule property, constructed the houses now existing over C and D. The plaint schedule A to D properties are ancestral properties to plaintiffs dash and dash. Now, my lords, we are given to understand this. Why we agreed for compensation was at that point of time was that the 12th defendant, now 12th respondent before your lordship, son of 11th defendant before the trial court, he has a kidney problem. Still, in a way, it's in a flexible situation. Now, my lords, that was one part of it. And the other properties, C and D, are also not ordinary properties. They are also quite valuable properties. Other than A property, B, C, D, E are also valuable properties. So that's where the trial court's judgment that the other, they do not have share in Schedule A property, but they have share in all other properties is one thing. Assuming for a while, A also, in A schedule property also they have a share, assuming for a while. To that extent, in the FDP equities can be, adjusted. That's another thing that we can think of. But here we have a clear case where it is sold for the joint family purposes is what I am going to demonstrate before your lordship. The pleading in para 5 says that he had also constructed houses here is available from this paragraph. And then your lordship may kindly come to para 7. Para 7 of the plaint. Plaintiffs on 2/2/2012 approached the defendant 1 to 10 and they approached defendant 1 to 7, requested them to effect partition in the plaint A to D schedule properties between them. Now your lordships may kindly come to para 8. That the plaintiffs on 24/9/2012 itself brought the said fact to the kind notice of the defendant 1 to 7 and they informed them orally that to receive the compensation pertaining to the plaint A schedule property from the defendant number 12 and thereby give their share in the compensation. Defendant 1 to 7 said, we will receive the compensation and give share in the compensation is what they said is what the plaintiffs say. That means, my lords, everything crystals down or boils down to the sale consideration of the property. Now, my lords, your lordship may kindly see 8A, page 15. Defendant 1 to 1 and 7 to 10 have alienated through registered sale deed dated 31/3/2006. They admit. Then kindly come to para 10 minutes.
But they had the knowledge earlier also.
Yes.
That's the indication insofar as para 3 is concerned.
That's where I'm requesting your. Now your lordship may kindly see para 10.
Para?
Para 10. Plaintiffs on 26/9/2012 itself got issued a legal notice. Here they take it to 2012. And then page 17, my lords, 6th line from top, 7th line. The plaintiffs have sent the said legal notice under RPAD. Same was duly served to defendant 1 to 12. In spite of that, till date, none of them have neither complied the terms of the said legal notice nor replied the same. But the defendant 1, 7, 8 and 11, after receipt of said legal notice, personally approached the plaintiffs and thereby they assured them orally that they will give their legitimate share in the compensation attached to the plaint A schedule property and also the respective shares in B2D. What are they now looking at is the question that I put to myself. Is it because of the compensation they have come or is it because of the sale consideration? However, whatever they say, it is all that they want is whatever
Monetary.
monetarily D7 has received. He couldn't have received it. It should also have been apportioned amongst us is what.
But did D11 also represented, you also represented on compensation?
No,
No, it appears so.
no, they, 1, 7, 8 and 11 is what they say.
That's
But
right.
I did not. That question has not been put to me at all.
But 11 is you, no?
They have, 11 is me. They have said in the plaint is what I am bringing to your lordships.
Okay.
So ultimately what here they have to get is, they have to get from 1.
But you denied this.
Yes. Kindly see, Millers. Para 13. Different 7 behind the back of plaintiffs had borrowed a loan of 2 lakh from Shrikanteshwara Prathamika Sanna Kaigarika Gramina Abhivrudhi Bank, Nanjangud, by executing registered Adhara Patra, registered mortgage deed in relation to plaint A schedule property, and had cleared the same in 2006. On the other hand, such transaction including the Adhara Patra are in no way binding on us. They don't say when they had the knowledge of this. they don't attribute any particular date for this knowledge, but it's an admission of the fact that so and so had mortgaged the property. So it is reflected in the sale deed also, which my learned friend also, during the course of the reading of the judgment, your lordship came to know that in the sale deed itself, it is mentioned. I will just take your lordships through that. So this fact that there was a loan pending with the bank, and it is a Prathamika Sanna Kaigarika Gramina Abhivrudhi Bank. It's a PLD bank. That's also one aspect. And this coupled with what they have said in para 5 would show that it was for the benefit of the family only, entire thing was going on. Now, your lordship may kindly see, I'll just take your lordships through. In the written statement, we have said in page 39 minutes, para 5. It is could your lordship lay hands? It is humbly submitted by the 11 defendant that his first son is suffering from kidney ailment. And for his future security, this defendant has purchased plain scheduled property for a valuable consideration. And before purchasing the above said property, bearing so and so, he had verified all the revenue records and paid a sum of rupees 6,30,000 rupees. And in the next page, he mentions about this 2 lakh rupees loan. And also for the purposes of family necessity, the 7th defendant has sold the above said land in favor of. That's what is mentioned. I request your lordships to kindly see the cross-examination portion of PW2. Page 94. Page 94, second paragraph.
PW2 is
Kenchegoda's wife, aunt of D7 and all these plaintiffs. That they had also pleaded in the plaint that we will also challenge the revenue record entries being mutated only in the name of our brothers is what they have said in the plaint. I did not want to read all those things because in the plaint they have said. Now your lordship may kindly see this page 94, second para. ಏಳನೇ ಪ್ರತಿವಾದಿಯ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಆಗುವಾಗ ಆತನ ತಂದೆ ಮಾಲೇಗೌಡ ಸಿದ್ದಮ್ಮ ಆತನ ಸಹೋದರರು ಜೀವಂತ ಇದ್ರು. ಏಳನೇ ಪ್ರತಿವಾದಿಯ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಆಗುವಾಗ ಯಾರದು ತಂಟೆ ತಕರಾರು ಇರಲಿಲ್ಲ. We did not object for the change of mutation in the name of D7 is what they admit here. Next, fellows. Page 95.
This is Kenchegowda's wife saying?
Please, fellows. PW2, witness of plaintiff. Page 95. Fourth line from top. 2005ರಿಂದ ಈ ದಾವೆ ಹಾಕುವವರೆಗೆ ಅಂದರೆ 2013ರವರೆಗೆ ಏಳನೇ ಪ್ರತಿವಾದಿಯ ಸಹೋದರಿಯರು ಆ ಮಾರಾಟಕ್ಕೆ ಯಾವುದೇ ಆಕ್ಷೇಪ ವ್ಯಕ್ತಪಡಿಸಿಲ್ಲ ಎನ್ನುವುದು ನಿಜ. She says that from 2005 till 2013, none of the sisters of D7, there are other 6 sisters, none of them have objected to the sale in favor of the D11. Page 96, minutes. Because it is RFA, I'm reading the evidence, otherwise I wouldn't.
Sisters of D7. No?
Sisters of D7 have not objected to the sale from 2005 to 13.
2006 to 13.
5 to 30. 6 to 30. 2030. Plaintiffs. Plaintiffs. 7 sisters. Thank you. page 96 minutes. 7ನೇ ಪ್ರತಿವಾದಿ ನಂಜನಗೂಡು ಭೂ ಅಭಿವೃದ್ಧಿ ಬ್ಯಾಂಕಿನಿಂದ 7 ಲಕ್ಷ ಸಾಲ ಪಡೆದಿದ್ದ ಎನ್ನುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆ ಸಾಲ ತೀರಿಸಲು 7ನೇ ಪ್ರತಿವಾದಿ ದಾವಾ ಎ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯನ್ನು ಮಾರಾಟ ಮಾಡಿದ್ದಾನೆ ಎನ್ನುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಮುಂದುವರಿದು 7ನೇ ಪ್ರತಿವಾದಿ ಮಗಳ ಮದುವೆಗಾಗಿ ಸಾಲ ಮಾಡಿದ್ದಾನೆ. ಮಗಳ ಮದುವೆಗೆ ಮಾಡಿದ ಸಾಲ ತೀರಿಸಲು ಕೂಡ 7ನೇ ಪ್ರತಿವಾದಿ ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಿದ್ದಾನೆ ಅಂದರೆ ಸಾಕ್ಷಿಯು ಇರಬಹುದು ಎನ್ನುತ್ತಾರೆ. PW3, my lords, page 98.
Yes.
She also says by consent the Katha is last 2 lines, my lords. Katha is changed in the name of plaintiff. That may not be. Yes, sir. Now, my lords, this one, DW1, my lords. One 119 minutes. Page 119. From bottom, 9th line. 7ನೇ ಪ್ರತಿವಾದಿ ಬ್ಯಾಂಕ್ ಸಾಲ ಬಾಕಿ ಇತ್ತು ಎನ್ನುತ್ತಾರೆ. ದಾವಾ ಎ ಶೆಡ್ಯೂಲ್ ಸತ್ತು ಖರೀದಿಸಿದ ನಂತರ ಕುಡಿಯೋ ಲಾಶಿಪ್ ಲೇ ಹ್ಯಾಂಡ್ಸ್. 7ನೇ ಪ್ರತಿವಾದಿ ಬ್ಯಾಂಕ್ ಸಾಲ ಮರುಪಾವತಿ ಮಾಡಿದ್ದಾರೆ. ಸಾಲ ಮರುಪಾವತಿ ಆದ ಬಗ್ಗೆ ನನ್ನ ಬಳಿ ದಾಖಲೆ ಇದೆ. ಅದನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇಲ್ಲ. ಪೇಜ್ 120. ನನ್ನ ಮಗನಿಗೆ ಕಿಡ್ನಿ ಸಮಸ್ಯೆ ಇರುವ ಬಗ್ಗೆ ನನ್ನ ಬಳಿ ದಾಖಲೆ ಇದೆ. No, my lords, I'm just leaving it at here. That not much of evidence is adduced by both the parties in this. I would like to rely upon 3 judgments. This Pavitri Devi's case, quite an old judgment. One thing that needs to be considered here in my respectful submission is this. They admit that it's a joint family, para 5, and other pleadings by themselves and admission in the examination chief and their own pleadings would demonstrate that they considered it as a joint family. Whether individually this person could have sold it or not is something that we need to see. Now the sisters were.
These things.
That's his case.
Yes.
Even he is the only male person in the family, D7. So we can say that he is the karta of the family and he had every right to sell the properties. And in the depositions, earlier also it has come into picture that the father of this, because the other branch did not have children, the father of this person and these plaintiffs also, they had maintained the entire family. And post that D7 was the only member.
So D7 was karta of the family is not disputed.
In a way, that we don't.
They don't say he was not acting as a karta of the family. Whether the plaintiffs say.
They say he could not have alienated all by himself is what they say. It is not under section 8 they are claiming. Section 8, if they claim under section 8, my lords, then probably the rights would be independent. Now they say it's all ancestral family property, joint family property, we are all together. So he alone could not have sold. He can sell if it is for the benefit of the family. The fact that
That means,
Please.
that means that defendant number 7 was the Karta of the family.
that's what they are admitting that. By their conduct, they are admitting that. If they are admitting it by conduct, then what happens is my sale deed. I would like to read the sale deed itself, my lords.
Which page is that?
Pardon, miss?
The sale deed, you want to read it?
Please, my lords, sale deed. Brother, page. Sale deed, page.
P14, page 152.
P14, exhibit P14, my lords.
Page 152.
In paper book, it's at 152. Perhaps in 153, it says. Could your lordship lay hand?
Yes.
Second paragraph. PLD ಬ್ಯಾಂಕಿನಲ್ಲಿ ಮಾಡಿರುವ ಸಾಲ ತೀರಿಸುವುದಕ್ಕಾಗೂ ಮೈನರ್ ಮಕ್ಕಳ ಪಾಲನೆ ಪೋಷಣೆ ಎಕ್ಸೆಟ್ರಾಗಾಗಿ ಇದನ್ನ ಮಾರಿದೀವಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿ ಮೈನರ್ ಮಕ್ಕಳು ಅಂದ್ರೆ ನನ್ನ ಮಕ್ಕಳು ಅಂತ ಬಂದ್ಬಿಡುತ್ತೆ ಅಂತ ಒಂದು ಪ್ರಶ್ನೆ.
If you refer to Kannada documents more, then it may be difficult for us.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇರೋದು ಎರಡೇ ಪ್ರಶ್ನೆ. ಆಮೇಲೆ
We can do one thing, possibly, whichever paragraphs you have read,
that alone we will translate in English.
that's translate and give it.
That would be fine, madam. That would be wonderful. In
Rather
fact,
than,
I
you know,
wanted to
bothering-
mention that in other cases also, because we will be coming here regularly, and that would be really, this paragraph, this, and, when it.
No, if I'm there to. do
Fair
it,
enough,
but,
madam. I'm not.
If in the form of a written synopsis which you file, in that, you can.
Call out this in English
In
translation.
English.
That would be better. I will
Also,
do
there
that.
is other way also, we can, you know, the way you are translating, we take the translation to be that, but we don't know, you know, we may miss out or we may forget also whatever you have said so also.
Please.
Better
My
would be
only-
to,
All that I want to bring to your lordship's kind attention is that the fact that this was sold because of the pre-existing loan also is demonstrated, reflected in the sale deed is what I would like to say. That's one thing. Earlier loan.
the loan was taken by the 7 or, but it was on behalf of all the,
Unless it's a PLD bank loan. Bank loans are taken for the agricultural properties. What other property? So it is their own case that he had mortgaged that property. The very same property had mortgaged. Maybe the bank had come on them. So he had to sell it. Either to the bank, he should have lost it. So probably he thought, I am a better person. In the bargain, I will also clear the loan and then he will take that amount.
although he doesn't, the learner, the trial court doesn't really refers to all this. The cumulative of what you have arguing,
Please, minutes.
doesn't refer in the manner, in the impugned order.
It says that there is a reflection. Well, it's probably what I say, I'm not, to be very honest with the court, what I say may be considered by this court in two ways. One is that you are attributing those intentions which was not there. That can also be said by this court. Or the other way of looking at it is, no, that could be the only possible way. Now, my lords, under section 96, we have two things. If the court could not have come to a conclusion at all, then we can just think of it. If the court could have come to the same inference, drawn the same inference, but reasoning might not have been so well given.
That's right. No,
Then
this-
your lordships will exercise the direction slightly differently. And the strengthening process can happen while reappreciating the evidence.
Possibly-
Reappreciating is not just, sorry, Ms.
Sorry, possibly you can argue that this is also the evidence which could have been reflected by the trial court in its order in support of its finding.
Please.
The finding is there, but it could have been reflected in this.
Reappreciation wouldn't mean that when we are disagreeing itself with the finding. Reappreciation can also be a strengthening process is what personally I feel. I leave it to your lordship's members. The next judgment is Sundar Das case, my lords. What is alienation, mullahs? I do not want to trouble your lordships. I'll give the short synopsis with those judgments. But para 10 may be the relevant portion. And then Kehar Singh's judgment is another judgment. Para 20, 24, 25 and 26, I will give the short synopsis of it.
That's all. Thank you. Yes,
Yes,
5 minutes.
Yes, my lord. If the sale deed exhibit P14 is seen, in that the recital says like this. D1, D7, D8, D9, D10 are the vendors. The recital says, other than us, nobody else has any right on the scheduled property. Nobody is a successor to the property. We are entitled to sell the scheduled property. The scheduled property is being sold by us for the purpose of clearance of the loan that we have borrowed from PLD bank and for the maintenance and the taking and help of the children and to buy some other property. No, my lord, that cannot be read in isolation. If the sale deed mentions those 4 members' name and says nobody else other than us is entitled to sell this and for the loan borrowed by us from PLD bank, it only means defendant number 7 and his family. It cannot be read to mean that therefore it must be the loan of defendants, the plaintiffs and other defendants also, and for that there is no pleading also. That's first part, my lord. As regards not being challenged, he says they did not object to it from the PW2 in her cross-examination says from 2006 till 2013, the daughters did not object to the sale. No, my lord, it cannot be barred by limitation because under Article 109 of Limitation Act, for sale of for the alienation of the property by father or karta of the family, the limitation for challenging it is 12 years from the day possession is taken, assuming the 2006 Article 109 of the Limitation Act.
It's not the challenge. It's not the challenge in respect of the partition. Partition, yes, okay. But sale.
It is sale only, my lord.
Sale was known to you. Sale was known to you much prior to 2013. That's what they say.
My lord, there is no pleading.
How would you answer para 5 of your plaint?
Yes, my lord.
See, you say, we'll read it. The plain C and D scheduled properties were initially vacant sites. After demise of Male Gowda, the plaintiffs and the defendant 1 to 10, out of the income derived from plaintiff scheduled property, constructed the houses now existing over plain. So what does it say? Signify? It signify the scheduled property A was sold and the receipts thereof were used for the construction at plain C and D property.
My lord, A scheduled property is an agricultural land.
We are concerned with that only.
Yes, my lord.
That's right.
Therefore, I'm saying it is not by the sale. It is from the income of the property. It yields income.
Derived from. So that means you impute, at least you had the knowledge.
My lord.
You had the knowledge.
My lord, it may be reading too much in between the line, my lord. The reason is.
No, why too much?
My lord, it is an agricultural land. income from the agricultural land is.
We don't know what nature of the land is. What is being read here is by the other side is that from A scheduled property, there was a construction in C and D. And this is your stand. That's what being argued.
My lord, that is not the case in the written statement. They have not said that I have done this like this.
This is imputing you. This is imputing you. This is
My
your
lord,
plaint.
I agree.
That's right.
It's a case of bad drafting, not an adequate drafting. All I am saying is income derived from plaint schedule. It's an agriculture.
We will not say bad drafting. There is an averment. How would you read that averment? We want to know.
My lord, I am saying this, there is no suggestion that in the cross-examination of my witness, to the best of my knowledge, there is no suggestion that I had the knowledge of or any of the plaintiffs had the knowledge of.
Why should there be a suggestion when there is an averment like
My
this?
lord, this also can mean that it is the income from the property which is an agricultural land.
We don't know. We don't know. The sum and substance meaningfully read from A, we got money, which was used for construction of C and D. What does it signify? That you had the knowledge with regard to the sale of A. That's what being argued.
My lord, all I can say is when this was said in the plain, in the written statement also, they don't say that.
Read para 5
Yes, my lord.
of the written statement. That is at the page 39.
Page 43, my lords can see. The allegations in para 5 of the plaint is again false and baseless, and plaintiffs are hereby put to strict proof of same. It is submitted by the defendant. Plaintiff and defendants 1 to 10 do not have any rights over plaintiff's property as stated. My lord, the problem is this. And it's not rare, my lord. The case of drafting comes to interpretation at this stage.
That's the
If
relevance of the drafting, you know.
I agree, my lord. I agree. Now, if it is seen in entirety, the relationship is not in dispute. It can be seen that not only that my interpretation, even the defendant did not approach it from that perspective, your lordship sees. In fact, their approach is, my lord, that I am not entitled for any share in the property. Now, how can it be said that you also are benefited by the property, or that you are aware of it and therefore the sale is for joint file property? If it,
Now see para 7.
yes, my lord.
You will read it in a context. The plaintiffs on 212, considering the attitude of defendant number 1 to 10, did now you don't say about 11 here.
I'm sorry, I didn't get the para. I'm sorry.
Sorry, para 7 of the plaint.
That's one plaint. I'm sorry. Yes, my lord.
Did contact and approach defendant 1 and 7. You don't say 11. Okay?
Yes, my lord.
And thereby requested to effect partition in the plaint.
Yes, my lord.
A to D properties between them and defendant 1, 2, 4 and 10 by meets and bounds, and thereby put them together in separate possession of their legitimate share over the same. In turn, the defendant 1 and 7 initially request, but deliberately they will honor the plaintiff's said request, but deliberately they were postponed and the same till 23/9/2012 by placing one or the other unjustifiable reason. While so on this, the plaintiff came to defendant number 12, had acquired the lands in and around this Chhatrak Taluk, Mysore for industrial development and made all arrangement in favor of the concerned landlord.
My lord, if next para at page 14 is seen, there it becomes clear. I inform that I became aware of the sale on 25th September 2012. Para page number 14, because my lord, till here they say defendants up to defendant number 10 because I was not aware of the sale. Page number 14, some 10 lines from the bottom, my lord. The plaintiffs on 25th September 2012, suspecting their attitude, made inquiry in relation to documents attached to plaint A and A to D scheduled properties. In the concerned respective office at that juncture, plaintiff came to know the below mentioned surprising and shocking news attached to the plaint A scheduled property. Therefore, my lord, I am saying, plaint has to be read as a whole. My case is that till 25th of September 2012, I was not aware of the sale at all. So where is the question of me saying that I was aware of a sale of?
Where do you say in your plaint that you were not aware?
My lord, para 14, page number 14, I may permitted to, my lord, I may be permitted to start at para 8 at page 13. That makes more sense, therefore, that the plaintiffs on 24 September 2012 itself brought the setback to the kind notice of defendant number 1 and 7 and informed them orally that to receive compensation pertains to plaintiff A scheduled property from defendant number 12 and thereby gave their share in the compensation. Defendant number 12 is KADB, including their respective shares in plaintiff B to scheduled properties as per law. At that juncture, defendants 1, 2, and 4 to 10 by colluding with each other with the sole intention to defeat the legitimate right of the plaintiffs over plaintiff scheduled property and thereby make unlawful gain to themselves and to cause wrongful loss of plaintiff, orally proclaimed that they will not give any share in the plaintiff A to G scheduled properties. Apart from that, they orally proclaimed that they are going to alienate plaintiff B to D scheduled properties in favor of the required persons as soon as possible. The plaintiffs on 25th September 2012, suspecting they said attitude, made inquiry in relation to the documents attached to the plaintiff A to D scheduled properties in the concerned respective office. At that juncture, the plaintiffs came to know the below mentioned surprising and shocking news attached to the plaintiff A scheduled property. A. Defendant number 1 to and 7 to 10 have alienated plaintiff A scheduled property in favor of defendant number 11 through registered sale deed dated 31/3/2006.
Who is defendant number 12?
KDB.
Now that's what being argued by the senior counsel. If you see page 15,
yes,
the intent is only to get the benefit of compensation.
That's what observed.
My lord, it is very clear in the previous para also I have said, because the property was acquired. In 2012, if the property was already acquired, how can I say I want the property? And therefore, the para number 7 of the plaint clearly says the property was acquired and therefore I wanted compensation. If the property was not acquired, then fair enough. Where is the question of me asking for a share in that property physically, my lord? Therefore, my lord, if the plaint is seen as a whole, this is one stray statement which can be interpreted either way. Para number 5, as your lordship pointed out, our learned senior argued. But I have clearly said in paragraph number 8 at page number 14 that I became aware of the sale only in 25th September 2012. Where is the question of me challenging it earlier, my lord?
Yes.
And my lord, therefore, my lord, and under Article 110, if I have to challenge a sale, 109, I'm sorry, of Limitation Act, if I have to challenge a sale by the Karta of the family, limitation is 12 years. Now, taking the date of 12 years from the date they take possession of the property, taking the date as of the sale deed as the date on which they took possession of the property, it is within limitation.
But that was a non-issue, no?
Yes, my lord, it was not, but it was said, so said that we did not, since deposition was.
What is being said is 2006 is the sale deed and the suit was filed in 2013.
And answer to that is in paragraph number 14, I became aware of it only in September 20.
Your case is that you got the knowledge only in 2012.
Correct.
That's all?
Yes.
We have heard the counsel for the parties. The counsel for the parties shall file written submissions, synopsis, by giving reference to the judgments they have referred to during their oral submissions. Okay, within how much time?
2 days.
The submission shall also incorporate English translation of the paragraphs in Kannada documents of which reference has been made during the oral submissions.
Okay. I have filed written submission, but that doesn't have English translation. Therefore, I will
just file it only on those paragraphs, on your paragraphs.
I'll do.
Actually, we wanted to make an application, but now that my learned friend has said already 50% has been dispersed. Now we are neither with money that on his health issues, we had to take some call because kidney transplantation and all, it would take too much. He is even unable to go. Now what would happen? At least if we had not given if it had not been a consent award, my lords, we could have gone for, I thought, whether we can go for some compromise formula also. That's also not possible because they are not going to enhance once we have given consent. Even that probability is not there. And I sold my site for the sake of my son. And now that is also not there. We are really in a fix. In fact, we have been requesting the Honorable Court on various occasions to dispose this matter, my lords. Somehow it has come now, grateful.
We just, if you can also file a brief synopsis about the amount compensation paid earlier, now, how much is the balance, how much deposited, just file a brief.
Grateful.
Thank you. Next.
Thank you.
Just call that. Sheet. Hmm? Oh, you reserve it. Reserve, reserve. I didn't say reserve.
Field number 8, appear for the respondent, my lord.
For the applicant.
Yes.
Please, my lord. My lord, this, my lordship might remember, this is the challenge to the reference where there was closure of the
I
establishment.
remember that.
Please, my lord. My lord,
Yes.
I have 3 propositions to cite before my lordships. The first, my lord, is the result of quashing the order of reference will mean that the workers are rendered remediless, since the sole adjudicating authority is the Labor Court under the Industrial Disputes Act. My lordship had placed this question to my learned senior that what remedy will the workers have? And the answer given by him, my lord, was that they have an entitlement to prosecution. Just to seek prosecution of the management if the law is violated. My lord, my submission on that is that prosecution is an alternative remedy. The outcome at best for me is that the management goes to jail for 6 months. I do not get reinstatement or back wages if I pursue my prosecution remedy. My only remedy
That will not benefit you.
that will not benefit me. The only way I can get my reinstatement is through the labor court. I had already, my lord, filed my compilation, but
Reinstatement? Is it necessarily has to be a reinstatement?
my lord, that the usual claim of the worker is reinstatement, back wages, consequential benefits, and seniority. And then it's usually molded by the court as per the facts of the case after adjudication as to the position. My lord, I wish to rely on one additional.
Fundamental question was
Please.
whether you can force that.
Exactly, my lord. I'm just handing that citation on that point. Where the Honorable Supreme Court, my lord, this is the settled position of law. I rely at page 13, my lord. Para 23 of the citation. I've already handed over a citation, but since this question came up, my lord.
Which paragraph is
Para
this?
23, my lord. Where, my lord, the principles of adjudication of industrial law is laid down. 23, my lordship has found it. To sum up, the principles applicable to jurisdiction of the civil court in relationship to an industrial dispute may be stated thus, my lord, and I refer to 3, my lord. If the industrial dispute relates to the enforcement of a right or an obligation created under the right, then the only remedy available to the suitor is to get adjudication under the act. So this is the position of law as it stands even today, that in case I want, my claim over here, my lord, is violation of 25O, which is a right created under the act. And my remedy is also under the act as a self-contained code. That's my first submission, my lord. My lord, in fact, reinstatement, my lord, is the prerogative of the labor court. Whether not even the civil court, not the state government, not this honorable court, my lord, without adjudication, it's a limited prerogative granted only to the labor court.
How would you answer his submission that when it comes to closure, it is fait accompli?
Yes, my lord.
Fait accompli in the sense
It's
that
done.
is done. And the only thing is possibly, those prosecution Is there any judgment? Because Mr. Raghavan has referred to certain judgments.
I have in fact produced these judgments. I'll take my lordship through them. The question is, once closure itself is admitted, then he might be right, my lord. But here there's a dispute as to the factum of closure itself.
Closure is not, closure is disputed.
Please.
Closure is disputed, then this. Admitted in the sense, yes, as a factum, there is a closure,
No, we have not admitted. That is the case.
but it is not a bona fide closure.
No, 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 that is not my stance, my lord.
No, even saying, let's assume in a case,
Then it might be difficult for me. If I say it's closed, but they did not close it with good intentions. They have closed it in order to target me, etc. I might have a different case, my lord.
but are you still saying it's a there is a closure?
No, my lord, I'm saying it's not a closure in terms of the definition of closure. That's been my consistent stance in all my pleadings.
How do you say so?
Please, my lord, the pleadings may be referred to.
What are the pleadings say?
The pleadings say 2 points. One is that the company, the petitioner, is continuing its manufacturing activities by one means or another, but not through us. That's the first stance. The second is that there are 2 units. One is the Tumkur unit, one is the Bangalore unit. So the claim of the union is there's something called functional integrality, which means I've also produced the citation. I'll take my lordship. There's commonality of a number of factors. There's a variety of factors. And once I show that, my lord, then actually what has to be done is an entire seniority list has to be prepared. And
Is it a common seniority for both?
please, my lord.
Is it a common seniority for both?
Once I established on functional integrality, which is a question of adjudication, then that would have had to be done. And
But
then
is it your
goes.
case that there is a functional
Yes, it is.
commonality?
I have pleaded that.
You have pleaded that. And what is the basis for you to say?
My lord, there's commonality of management. I'll point out to the relevant part.
No, management,
Please.
common seniority,
Please.
interchangeable from one to there, transfer, interstate transfer from both the units.
All of those have been there.
You have said so. Oh,
So once I claim that, my lord, then I can't prove that on fact before my lordship. I have to prove it on evidence, my lord, on the anvil of evidence. My second, my lord, is here there are real and deliberate questions of disputes regarding the facts. My learned senior friend repeatedly submitted that it's an admitted fact that there's closure, so there's no question. In fact, all the citations relied on by him, my lord, they consider that closure is admitted. Here, closure is not admitted. So all the judgments placed by him are on a different footing, my lord.
okay.
Then, and my lord, thirdly, my lord, is that this entire petition is entirely premature because the challenge is to the reference itself. It's not after adjudication they have approached this court.
No, but reference can be challenged. No?
My lord, my submission is that for 8 years, they have managed to delay the case. By this date, the case itself award might have also been passed.
But they have challenged the reference immediately thereafter.
But my submission is this, my lord. The learned single judge granted 1 lakh compensation. That's around 1,000 rupees for a worker for 4 years delay. Now we are facing 8 years delay because they have not pressed the petition. The workers now, in fact, proving the case on facts becomes more and more difficult for me. And they have the management, I submit, my lord, that the law contemplates an unequal balance between workers and management. The management has the money power and it has the power over the livelihoods of the workers. And when the law contemplates inequality between the workers, then the law imposes certain beneficial protections for the workers. And it's a self-contained code which allows me to agitate my remedies. And what they're doing is saying you don't have even a right to agitate your remedies. Through our money power, we have stopped. They have the power to stop these proceedings for years on end, my lord. That's all, my lord. The
Okay.
citations, should I take, my lordship? I'll just say the proposition and then.
Just give that. You file just note of submissions. We will have it. When do you want?
Can it be had next Monday, my lords, 22nd?
Yeah, the counsel for the respondent has completed her submissions to come up for rejoinder submissions of Mr. Raghavan, re-notify all.
Please, my lord.
Monday,
Obliged.
you will give a note of submissions.
I'll bring it on.
All the judgments, everything.
Please, my lord.
See that matter, previous matter. Previous.
for hearing 230 matters. Serial number 10, Shri Devraj.
This is digital.
There, huh?
Yes.
Lot. But I had made submissions, my lord, in writ appeal 865. I had requested my lords to accommodate us to file a short synopsis of submission, my lord. Permit me to file it. Lord, I had taken my lords through the impugned order and pointed out, my lord, that it is based on two judgments. So far as the maintainability is concerned, one is Supreme Court judgment, another judgment of the same learned single judge considering a batch of petitions which arose from permanent Lok Adalat. My submission, my lord, was those two cases. Both the cases were in situations, one which came from the civil court, second which came from permanent Lok Adalat where evidence was recorded. In each of the cases, in the Lok Adalat case, there was evidence led, material was available. There was a quantification which was considered by the learned single judge as to whether the quantification was correct or otherwise. But they were all cases where there was material in the form of evidence which was available for consideration of the learned single judge, my lord, who considered, my lord, the case of compensation. My lord, in contrast to that, in this case, in these batch of 3 cases, my lord, there is no material available, and the material which is placed before the honorable court for consideration is one, bill of a private hospital, two, an estimation by the private hospital to say that in future this kind of an expenditure could be incurred. There is no disability certificate which is available. There is no evidence of whatsoever manner of any expert which is also placed before the honorable court. Therefore, my submission, my lord, was that even if the parameters of MVC is to be applied in these cases, the basic material which is required for such a exercise to be undertaken is not forthcoming in the present proceedings, and therefore my submission, my lord, is that this
Sir, we want to know what are the disputed issues,
Lord,
which should have gone there only.
Lord, so far as disputed issue is concerned, my lord,
Yes.
one, my lord, with
See,
regard,
it's like, I'm just sorry to interrupt.
yes,
One, there is an apparent. A man is walking, he falls in a manhole,
yes,
dies. Rest is per locator on the face of it, entitled to. There is no issue need to be gone. There are issues which, even then, writ jurisdiction, surely that can be invoked. Public law remedy.
yes,
But the only thing is, where there are disputed issues, surely maybe require an evidence to be produced, because there are disputed facts where surely you would say that it is not attributable to you, something what happened. It is attributable to a third party. The third party need to be here. The evidence need to be led. Your evidence as against their evidence, and the court comes to a conclusion.
yes,
In that eventuality, possibly according to you, and possibly the line of judgments, which says that that need to be decided by a civil court.
Civil court. Not, in this facts of this particular case, my lord, one, I have said, my lord, that I was not negligent because distances were maintained. There is a building which came up much later. From 1976, my lord, this line is there. Building has come. I have been told it's not within my jurisdiction or realm to consider those aspects so far as, because there is a local body in place, etc. We tried to have a regulation which has been, we were told, no, that's not your job. There is somebody else who has to do it. And apart from that, my lord, I made an application before the honorable court to say, if this needs to be considered, then the erring parties, there are other erring parties, even if I put everything against myself, bring them also. Like it's been done in other cases, my lord, even if liability is fastened, that needs to be apportioned. The learned judge says, because this is a public law remedy, I will not bring them on record. I will only fasten liability on you. And in the final order, he rejects my application to bring them on record. My submission, my lord, is if liability could be fastened on me, there is no, my lord, and it has been done, my lord. I have also produced judgment of the bench, my lord, of which my lord was a party, where apportionment was done by division bench, my lord, that my synopsis, page 34.
You have annexed 2 judgments.
Yes, my lord.
And I think a lot of work was done. On a lighter way, on a lighter side.
No, my lord, I thought.
I know, and I'll tell you one thing. I told my lord also, in fact, I recollect, with Justice Rajendra Menon, we had given a judgment. In fact, I was telling him I have to take that judgment out also.
Yes, my lord, I have got that judgment. Page 34, my lord, of my synopsis.
Yeah.
There, my lord, apportionment was done.
But that's a writ petition.
That's a writ.
An appeal. Writ petition, then appeal.
Yeah, an appeal. And my lord, so far as this was challenged in a SLP, and the question of law was left open with regard to, my lord, and this order was confirmed. No, I should have put it. Although, my lord, it's not very clear as to what is that specific question of law which has been left open. I presume, my lord, with regard to as to
quantification.
Quantification.
The principle that has been, culled out.
Yes.
That para 29.
Yes. Standard of compensation. It has to be assessed by taking advantage, taking the average CPI IW with base of 1982 in the year 1989 as per Kamala Devi's case. Index was 171 according to the Labour Bureau, Government of India's notification of July 2014. The CPI IW with the base year of 2001 for the year 2014 is 252. And the linking factor between based on general index for particular year would be 4.63. Therefore, CPI IW as in July 2014 would be so much. And then, my lord, the computation. Then apportionment, my lord, also has been done.
But even the Motor Vehicles Act multiplier was also invoked.
Yes. Para 24, my lord, of this judgment at page 43. There is reference to Ram Kishore's judgment, and municipality is also held liable. Para 26. One more aspect, my lord, is insofar as this honorable court's judgments are concerned, my lord, I had specifically relied upon order of the division bench of this honorable court, my lord, in writ appeal 4 of 2020, which is there at page 509 of my slightly larger compilation, my lord, of judgments, which was specifically placed for consideration before the learned single judge in the impugned order, my lord. There is the learned single judge seems to advert to the fact that we have relied on this judgment, but my lord does not say one way or the other as to its binding nature. In the synopsis, in the appeal memo, in the synopsis of submission that I filed before the learned single judge, which is at page 281 of the appeal memo, I specifically refer to it, and then at page 65, sorry, internal page 45 at page 72, paragraph 12. There is consideration and reference to this particular judgment is at page 77, paragraph 21. But my lord skips reference to the binding precedent, if I may draw my lord's attention to the synopsis that was filed, and this judgment was specifically, Lord, cited at
Let's
page
see-
280.
Let's see the judgment.
Yes, Lord, page 509 of my compilation. The judgment compilation, Lord, which I had passed on, in that page 509. My lords may see paragraph 3 in the facts. Respondent is the writ petitioner who filed writ petition under 226 of Constitution of India. As noted by the learned single judge, respondent's wife so-and-so died due to electrocution on 2nd of July 2012. Respondent's wife was proceeding on a bike driven by the husband of one so-and-so. At a particular place, a live wire, electrical line of 11 kV, which was passing over the road, suddenly broke down and fell on the moving motorbike, which caused grievous injury to Srimati so-and-so. However, as a result of severe burns caused by electric shock, respondent's wife unfortunately died on the spot. When she was taken to nearby hospital, she was declared as dead. On 10th of December 2012, respondent made a representation to the appellants, pointing out that his deceased wife was earning rupees 8,000 to 10,000 rupees per month. He pointed out that except a payment of rupees 1 lakh for funeral and other miscellaneous expenses, a reasonable compensation was not paid by BESCOM. There was one more representation made on 8th of July 2013 by respondent seeking compensation. Ultimately, in the year 2014, a writ petition was filed seeking a writ in the nature of mandamus directing the appellants to pay the compensation. By the impugned order, learned single judge directed that in addition to the compensation of rupees 1 lakh paid earlier, BESCOM shall pay provisional compensation of rupees 1 lakh to the respondent. For the additional amount, a liberty was reserved to the respondent to file a civil suit within a period of 4 weeks from the date of receipt of certified copy of the order of the learned single judge. It is this order which is subject to challenge by BESCOM by filing this writ appeal. Then, my lord, there is consideration. Then para 10 at page 514.
This is also on similar lines.
Similar lines.
Because they have been relegated to the civil court.
Civil court.
Pending that 1 lakh.
Yes.
Compensation.
Yes, ma'am. interim compensation here, my lord, in each case, my lord, different amounts. In this particular case, my lord, 5 lakhs they have received. I'm more, my lord, on the question of compensation as to how it's to be determined and the parameters to be adopted. Here, my lord, based on some private hospitals prescription that it could be so much, the same has been adopted and granted, my lord. If that is followed, my lord, I may be placed in a situation where, my lord, such claims will be made and without adjudication as to what could be the just compensation to be granted, my lord, I may face such claims. And that's the reason, my lord, we have taken up this issue for consideration. Now, my lord, one more aspect is what has been held against me, my lord, is in the Act, 2003 Act, there is provision 161. Lord, if there is an electrical accident, I am supposed to report it to the inspectorate, who's constituted under the Act. He, my lord, has to give a report. Now, my lord, what the learned single judge says is, there is a 161 report, and you have not challenged it. Although there is possibly an appeal to the government, you have not challenged it. Therefore, there is a possibly a finding of negligence. And therefore, the question of going into the issue of negligence does not arise at all. This is so far as liability is concerned. Lord, but in this case, what the petitioner does, my lord, is that first they approach the Child Right Commission, and Child Right Commission, my lord, initially passes an order and fixes liability, and that is sought to be enforced. At that point in time, my lord, I challenge that action to say the findings of the Child Right Commission is recommendatory in nature and it needs to be considered by the government in the frame of my lord, the statutory provisions. The 15.3, my lord, is the provision under which it makes a recommendation. The judgment of this honorable court, insofar as that is concerned, my lord, is that it's recommendatory in nature and therefore it has to be considered. The government considers it, comes to a conclusion that there is no negligence so far as the authority is concerned, fixes liability at 5 lakhs. That is paid. They have received it, not challenged. There is a finding, my lord, that there is no negligence on the part of the authorities so far as this accident is concerned. That has attained finality. While, my lord, it is put against me that 161 order had to be challenged, but then in the same set of facts and circumstances, they have taken recourse to another mode, got some compensation fixed, not challenged it. And my submission, my lord, is although it is technical, my lord, but it is binding on them and they have not challenged it. So, Lord, what is sauce for the goose is sauce for the gander. If not challenging 161 order should be held against me, as has been done in this case, then, my lord, not challenging the order passed under the Lord, other stream which they decided to take, but that is also binding on them, is my submission, my lord. In fact, we had said that this is nothing but forum shopping because they have gone there, they have got their rights adjudicated, etc. My lord, that has been negative by the honorable court in the impugned order. Second aspect of it, my lord, is that under the fatal accidents provisions, my lord, there are provisions which has to be invoked. There is a separate limitation prescribed there, process prescribed. And this honorable court consistently has been, has held that, my lord, recourse to that has to be adopted. That, my lord would find in para 6 of my synopsis. This is one of the grounds on which we had pointed out, my lord, that there are series of orders. Considering this aspect and relegating the parties to civil court for adjudication by fixing a interim compensation under public law remedy.
But tell us one thing, but what will happen pending decision of the civil court?
Lord, my submission, Lord, is that that is why, Lord, this petition was filed in 2019. By this time, Lord, the adjudication would have concluded before that court also. Because, Lord, of all this jugglery, Lord, matter is pending consideration. Otherwise, Lord, liability would have been fixed by looking at whatever evidence Lord, the parties would have placed before the court. Therefore, Lord, the regulation indicates that I have to pay a solatium immediately. Then, my Lord, here they have received, Lord, monetary support from various authorities, my Lord. In this case, first appeal, my Lord, Workf has paid, local board has paid. 5 lakhs is paid by KPTCL, my Lord, pursuant to order of the government. After consideration of recommendation of Child Right Commission. Therefore, my Lord, for the immediate purpose, my Lord, compensation is, the regulation also requires me to pay. Initially, my Lord, it was 50 lakhs, 50,000, enhanced to 2 lakhs. Now it is enhanced to 5 lakhs as immediate compensation without looking into the aspect as to whether who was responsible, etc. I have to pay. So long as it's a electrical, my Lord, mishap that has taken place, I have to pay as per the solatium regulations, my Lord, which I do, which I pay. My Lord, therefore, the scheme itself, my Lord, is to immediately give some relief. And then, my Lord, so far as quantum of compensation is to be fixed, my Lord, for that, my Lord, even if MVC, my Lord, parameters are to be adopted, even that contemplates, my Lord, existence of some evidence material to determine what are those components which have to be worked out, even for applying the multiplier formula, etc. My Lord, some semblance of evidence should be there. Although, my Lord, if we see the facts of this case, because the child is involved and all that, my Lord, of course, it may require a sympathetic view, but still, by that, my Lord, if this kind of computation is adopted, Lord, I will be, Lord, in a situation where I'll receive such, Lord, this will become a precedent. Lord, without any material, without any document with regard to disability, etc. Lord, I will have to pay compensation, Lord. That will be the situation. Some may be good, some may be bad orders. In the other appeal, there are 2 more appeals, my Lord. This is so far as this child is concerned, my Lord, was a 5-year-old child who goes into the next building, then tries to retrieve a ball. Then there is a electric arc which strikes him, and there is some electrical burns, my Lord, because of the shock. Now, in the second appeal 868 of 2022, fact by, Lord, here it's a 13-year-old girl.
What is the compensation amount?
In this, my Lord, 51 lakhs, 76,000 is the compensation amount.
In the previous one, it was 50 lakhs.
55 lakhs. One second. In the
5082 something.
5176, 1 second. Totally 50 lakhs 82,000.
Okay.
In 868, my Lord, 13-year-old girl, it is fixed at 5176.
Here also the same submissions.
Same, almost same, my Lord. Only additional factor, my Lord, is here they produced a disability certificate before court. That's the only
How
addition.
much is the disability?
Amputation of leg has taken place. Hand.
Amputation of arm.
Arm.
Right or the left?
It's a 75% permanent physical impairment, my Lord. That is what I have produced. And her left hand has been amputated from the elbow downwards.
What happened? How did the accident occur?
But what happened in this case was that there was a line So her veil had gone on the line. She had taken that veil out. At that point, he has come in contact and.
Here,
she
my
has,
lord, this is a
gotten
case of
electrocuted.
distribution line. This is not a transmission line, 11 kV line, which is there in all the roads. She was climbing the stairs. Her veil has flown and it has gone onto the
It's stuck
line.
there.
Yes. And then she had a mop stick. She tried to use that and tried to take her mop off. In this case, my lord, there was no violation of distance, etc. It has been held that everything, all those things were fine. But because she tried to use the mopping stick to try to retrieve that veil, it proved to be very costly, my lord. She had to lose a limb because of that process. There is a, my lord, here also, my lord, they approached the Child Right Commission, then a recommendation, and consideration by government, granting of interim compensation, directing them, my lord, for to approach civil court insofar as other aspects are concerned. Otherwise, my lord, facts are very similar so far as this case is concerned. I've tried to reduce, my lord, all the facts, my lord, into a short synopsis, my lord. Told. In this appeal, my lord, that disability certificate, Annexure F is at page 131, which says, my lord, 75%. This is issued by Directorate of Empowerment of Differently Abled. There seems to be no dispute with regard to that aspect. No, my lord, that
Is the negligence attributed?
nothing, zero. So far as I'm concerned, my lord, the line is in, it's a distribution line. And that is at a correct distance.
The distance between the building and the wire,
There's a finding, my lord, that 1.2 meters beyond that it is there.
permissible limit.
Yeah, permissible limit. There is no problem with the distance, etc.
Okay, what is the third one?
Third one, my lord, is case of death. This is a case where in an arachidonate plantation, Lord, there is an IP line which is coming, which is again a distribution line, 11 kV, my lord, line. 3, Lord, workers, they were trying to pluck, Lord, pepper. So they have to shift from one tree to another. It's a 20-foot ladder that they were using made of aluminum. So when they were shifting it from one tree to another, they hit the line. And one of them got electrocuted, my lord. The other two had shock, but not much happened to them. He died. This is a peculiar case, my lord, where it is a distribution line, which specifically, my lord, in this appeal, 861, the transmission utility is arrayed as respondent number 1. Distribution utility is arrayed as respondent number 2. Respondent number 1 says that it is not my line. I am not responsible for this line because it is not my line. It doesn't come under my jurisdiction at all. That contention, my lords would find at page 41 of the page 41 of this appeal in the impugned order.
How can that be an objection? Who is maintaining that line?
The my lord, second respondent maintains that line. The distribution licensee.
Who had put it? Who had put that line?
Distribution licensee.
Okay.
It is distribution, my lord, under 66 kV, it's all distribution line. Beyond that, it becomes transmission. Earlier, my lord, there was only one board called KEB, Karnataka Electricity Board. With the reforms, first, my lord, there was unbundling of generation and distribution and transmission.
Separated.
Then, my lord, second stage was that transmission was removed and kept with KPTC, transmission utility. Everything else has been under the jurisdiction of 5 distribution companies. And there is clear segregation, my lord. 2003 Act itself bifurcates transfer of employees, transfer of assets, etc., is statutorily provided for under the Act. In that process, my lord, this definitely belongs to the distribution entity who's also arrayed as second respondent. Lord, first respondent says in the objections, which is also noted in the as a contention in the order itself, internal page 21. In 861, my lord, in the appeal memo, it's at ink page 41.
This is with them. This is- Which page you said?
Ink page 41, internal page 21.
Yes.
C, contentions of respondent number 1, Power Transmission Corporation. Maintenance of 11 kV feeder line does not come within the purview of KPTCL and falls within the control of supervision of the second respondent. That's a specific, there is detailed pleading, my lord, with regard to this, which is referred to in the impugned order as a contention raised. Then consideration of that is at page 87. This writ petition 1383 of 2020 goes on, my lord, to hold that there is that particular aspect as to whether liability should be of respondent 2 or 1, that has not been gone into. I think, my lord, that's because of the finding, my lord, of the inspectorate, which my lords would find at page 189. The translation is at 189. Kindly see this, my lord. This is the report. This first reference is a reporting of an incident by the distribution licensee as reference number 1. Reference number 2 is a letter from the distribution licensee. Kindly see entry number 6, date of receipt of first information report and officer submitting it. This is from distribution licensee. Then, my lord, the inspectorate refers to the incident and details of the accident. Then at page 193, the last paragraph, unnumbered paragraph, second unnumbered paragraph at the bottom of that page, as stated by Shri Yogachar, section officer of O&M so-and-so branch division, SESCOM, which is the distribution licensee, with regard to the accident on 22/2/2018 at 1:44 p.m. Shri U.S. Lokesh, owner of the coffee plantation, informed about the electrical accident over phone, and immediately he intimated F1 so-and-so center to turn off the power, and thereby got the power turned off, and thereafter came to the spot with his staff, and on inspection found that Subramania lied dead on the spot, had died due to electrocution as a aluminum ladder came in contact with the electric line passing through the above when he tried to reach one tree to another tree by taking the aluminum ladder. 3 wires of F1 so-and-so line are at 24 feet, 27 feet height from the ground level. Then, my lord, in the opinion at page 197, as per the report submitted by so-and-so, Deputy Electrical Inspector Hassan to this office, by visiting the spot and conducting investigation of the said accident, it is observed that on 22/2/2018, Sri N.M. Subramania, son of so-and-so, while taking the aluminum ladder used to reach the pepper creepers for harvesting under 11 kV transformers and the said 20 feet aluminum ladder came in contact with the said transformer at the spot, due to which he died on the spot due to electrocution. With regard to the said accident case, instead of using the aluminum ladder to harvest the pepper in coffee plantation, had he used appropriate grade insulated fiber, wooden ladder, and had he taken precaution while taking the ladder under 11 kV electric transformer, he would have prevented the said accident. If the breaker installed to 11 kV feeder had tripped at the time of accident and had electrical supply was stopped, severity of the said accident could have been prevented. Wherefore, it is opined that there is violation of regulation 64(1) and 2 of CEA regulation relating to safety and regulation 45(2) Roman 2 of electrical supply regulations of 2010 by the concerned KPTCL. This is the only place, my lord, where the transmission utilities name has been used by the inspectorate, possibly, my lord, because historically, my lord, they've been using KPTCL as a generic term. This order is not even communicated to the transmission entity, my lord. Kindly see copy mark 2, serial number 4, the distribution entity. Therefore, my lord, what has been put against the transmission utility is, rightly or wrongly, your name finds a mention in this. You did not appeal against this order. Therefore, you have to be the only person who's to be fastened with the liability. That's the finding, my lord. I'll take my lords to that finding. The question of challenging this order will not arise, my lord. I was neither notified of this, nor this order was communicated to me at any point of time. Only, my lord, when writ petition is filed, I am arrayed as a respondent. But when it comes to the liability is fixed only so far as I am concerned. Although, Lord, I am nowhere connected to this particular line at page 108. Roman 3.
Nothing against the distribution entity?
No, nothing. And one more aspect, my lord, is I filed an application to implead the landowner, Mr. Lokesh, at 109, page 109.
But why do you want, what was the reason for impleadment?
To say, my lord, the report, even the report indicates that it was his fault of providing uninsulated ladder, which was being used when they know that there is an IP line which is coming into the, which is a necessity. But if you have to have a irrigation pump set, my lord, it has to be fed by a line. It's a necessity. It's there, and it's at a distance of 24 to 27 feet is the distance between the ground and the line. Lord, if it had to be moved, then the inspectorate says you should have used a good quality insulated ladder that could have prevented. So the allegation in the complaint, my lord, is also the complaint which was lodged by the, my lord, relatives of the deceased, is against, not against me. FIR is also filed so far as Lokesh is concerned as the accused, because of his negligence, the accident has taken place. Otherwise, my lord, it's not a case where line snapped or the line was sagging or a leakage, escape of electricity. No such allegation is there. It is a case where the ladder was taken and it was made to touch the 3 lines, and it led to, if it was insulated, nothing would have happened. So everywhere, including the complainant, makes an allegation against the owner of the land. He was not impleaded. I made an application for impleadment. That, my lord, is summarily rejected at page 109, Roman 6. Application for impleading filed in writ petition number 1383 of 2020, IA number 1 of 2022, seeking to implead the owner of the land, and the application filed in so-and-so seeking to implead the owner of the building as well as BBMP are liable to be rejected. This is with the finding, my lord, that because it is public law remedy, I will not expand this and take it any further, I will only fix liability on the entities. And that will not be enlarged, my lord. That's the logic by which, my lord, the applications are rejected. My humble submission, my lord, is that if the court is in the writ jurisdiction is fixing liability, then, my lord, as a consequence of that, my lord, it needs to be the issue of who's liable and how it's to be apportioned, my lord, is also to be looked into. My lord, the finding of the court, my lord, is at internal page 57 of the impugned order, ink page 77. It refers to the two applications. Para 31, scope of grant of compensation in an action invoking public law remedy cannot be enlarged into a further inquiry relating to the apportionment of liability amongst joint tortfeasors when they are private entities. Whether acts of the owner is providing an aluminum ladder as well as the act of constructing a building within the prohibited distance by the owner of the property contributing to the accident would make them joint tortfeasors, and if that were to be so, manner of apportionment of liability is also an aspect of separate and further inquiry which cannot be made in the writ proceedings. Then he refers to Bhagya Bai's judgment, my lord, which in turn refers to Supreme Court's judgment in Shaila Kumari, without noticing the fact, my lord, that that issue arose from a suit where there was proper inquiry, investigation, etc. material was available, and ignores, my lord, Justice Oka's judgment, my lord, which I pointed out at page 590. Therefore, my lord, my submission is, insofar as this case is concerned, my lord, the learned single judge, my lord, has completely lost sight of the fact that the line did not belong to the entity which has it owns, and my lord, it has been. One more aspect, my lord, is in this case, initially, my lord, the specific pleading was that grant me interim compensation and allow me to go to civil court. Of course, my lord, when all of them got clubbed, they tried to amend the pleading in that regard. But originally, my lord, I think specifically their case was that interim compensation is to be paid and they have to be relegated to civil court for fixing of compensation. Therefore, my lord, my submission, my lord, is that so far as 861 is concerned, my lord, case of death, the learned single judge, my lord, has completely misdirected himself in directing the transmission utility to pay the compensation. And so far as other two are concerned, my lord, I've made my submission. They have got specific orders from statutory to another statutory process, which they chose, and then, my lord, taken compensation. Interim compensation is paid, my lord, and they had to be relegated. There's one short synopsis, my lord, so far as 861 is concerned. Case of death.
Yes, who will argue? You are in which matter, ma'am?
My lord, I appear for the respondent number 1 in two of the matters, my lord. In writ appeal number 865 and in writ appeal number 868. That is both the children, my lord. The
Three broad submissions.
please, my lord.
One is why a writ court? Two, when disputed questions. Two, on the aspect of compensation granted. Three, also when there is no negligence attributable or cannot be proved, or and there was no concern insofar as the appellant is concerned. How can the liability be fastened?
Please.
These are three broad.
Please, my lord. The other, like my lord has pointed out, first issue is in respect of whether the petitions were maintainable before this court. Second, my lord,
I don't think you should really dwell with that.
Please, my lord.
That there is no dispute.
Please.
It's like this. There is
Please.
remedy is available, but in facts.
Please.
That's what being argued, not in these facts.
Please. The first, my lord, is in respect of the nature of the liability of the appellant concerned herein. The second, my lord, is the submission that was made in respect of the whether this court could have looked into it entirely or should have relegated the petitioner after giving some amount of nominal compensation, as has been stated by them, to the civil court. And the third, my lord, is in respect of the quantum of compensation itself and what would be the methodology to actually arrive at such a at the compensation to be looked at. These primarily, my lord, it is these three aspects, because insofar as the nature of the accident and the nature of the injury is concerned, there is no real dispute, inasmuch as they accept that this is a case of electrocution, that both of them got injured by electrocution. The manner in which it took place, that is not disputed. So therefore, my lord, it would be limited to these three aspects, as my lords has pointed out. The before I go into the judgments, my lord, because I am also relying on certain judgments, which has also been relied upon by the learned single judge. Just very brief facts, my lord, in both these cases to make it a bit clear. In the first case, my lord, that is writ appeal number 865 of 2022. We are concerned with a boy who at that point of time was aged 5 years, 8 months. Ma'am.
So we will just deal with it separately
Very well.
in the last.
Please, ma'am.
Let's take the last two first.
Very well.
The accident occurred. One
Please.
is that wheel went and stuck at the cable.
Please, my lord.
Maybe the attempt was to remove that wheel. There was an electrocution. That's one. Two is insofar as the
Boy is
insofar as the between the transmission concern and the distribution concern, that particular cable was being operated, installed, everything by the distribution company, not by them.
My lord, the second case that my lord is referring to is being argued by my friend, my lord.
Very well.
So I am only looking at these two cases.
Very
my lord.
well.
If I may address on these two cases. So therefore, my lord, the first case is in writ appeal number 865. That is in respect of the 5-year-old boy. He was around 5 years, 8 months, my lord, at the time of incident. That is in 2017. My lord would recall that he came in contact with the induction zone. So he went to the neighbor's terrace, and because of the 66 kilowatt transmission line, he comes in contact and he is electrocuted. My lords had in fact asked if there are any recent photographs. I in fact have those photographs, my lords. If my lords permit, I'd pass them on.
See it.
Please, my lord, since my lord had asked this specifically on the previous occasion, he has suffered, my lord, 80% burns with 40% deep burns. He has gone through some amount of surgery, but he is in requirement of some more surgery in respect of these burns. Because one, there is a very high risk of infection. The other is that there is a very high risk of there is a high level of pain because of the nature of the injury, that it causes a lot of burns. That is the nature of the injury insofar as the first case is concerned, my lord. Insofar as the second case is concerned, we are dealing with a girl who was 13 years at the time of the incident. She, my lord, like my lord had pointed out, her veil had gone in and she, in the process of getting it, she had gotten electrocuted. She has suffered, I've placed on record the disability certificate, which is 75% permanent disability. She has lost one arm and she also has severe burns on her thighs, which remain, my lord. Those burns on her thighs remain. This is the nature of the injury insofar as both of the respondents are concerned. The amount of compensation that has been received, my lord,
Will come later.
very well, my lord. I'll get to the question of
First,
liability.
Then possibly now you have to, how would you attribute what has happened to them?
So the question of liability, my lord, what is the nature of liability insofar as the appellants are concerned? That, my lord, in fact, before I go to the judgments that I am relying upon, primarily, my lord, I'm relying upon three judgments. One is the oleum gas leak case, where the principle of absolute liability was first laid down to say that how do we understand strict and absolute liability, and the fact of negligence, whether negligence is a factor to be considered or not, was looked at. And it was held that when there is a company or when there is a corporation or when there is an establishment that is producing inherently dangerous and hazardous substances, then the question of negligence is not something that is to be looked at. Second, my lord, the judgment that I'm relying upon is the judgment in Shail Kumari's case, where the Honorable Supreme Court has looked at this and has applied the principles of strict and absolute liability in respect of cases of electrocution. Third, my lord, is the decision of this honorable court in the division bench judgment in Bhagyabai's case, where it looks at the judgment of the apex court in Shel Kumari, and thereafter he applies the principle of strict and absolute liability and also orders compensation. In fact, my lord, in Bhagyabai's case, the principles of Motor Vehicles Act that is the principle of compensation. These are primarily the three cases that I'm looking at. Before that, my lord, if I may just take my lords through the learned single judge's order, which looks exactly at this point in terms of what is the nature of liability. The nature of liability of the power transmission companies, and how is one to understand that in respect of these incidents. If my lord could just Lord, the learned single judge's order in writ appeal number 865, my lord. It starts at page 28. From page 69, my lord, the ink page 69.
Yes.
In page 69, paragraph 7, my lord, is where maintainability of the writ petition is looked at page 69. At para.
Come to page 84.
One minute, please, my lord. Apportionment of liability, my lords. Please. My lords, my lord, before that, if I may request my lords to have a look at page 49, my lord. The reason is this. The nature of liability of transmission, utility, and distribution companies is dealt with in that paragraph at page 49, my lords. My lord, paragraph serial number A5 and then 6. 6 is the nature of liabilities as follows. Liability under common law. The power supply company in these matters have sought to repudiate liability on the ground that the acts of negligence by the victims was the cause of contribution for the accident, or that the intervening acts by strangers, third parties were responsible for the accidents. The principles of strict liability was evolved in the case of Ryland versus Fletcher. Lords, it goes into, learned single judge goes into the issue, into what was laid down by Ryland versus Fletcher. And then at point number 3, my lords, at page 50, looks at the case in MC Mehta. The apex court in the case of MC Mehta, Supra, where claims for compensation were sought on behalf of persons who had suffered consequent to escape of oleum gas from the units of Shriram Foods and Fertilizers Industries, has laid down the law as regards consequences of actions where inherently dangerous activities are carried on. The principle of absolute liability was laid down where liability was made absolute. That is strict liability sans defenses. The observation of the apex court at para 31 is self-explanatory and reads as follows. And this is the principle, my lord, that was laid down. We would therefore hold that where an enterprise is engaged in a hazardous or inherently dangerous activity and harm results to anyone on account of an accident in the operation of such hazardous or inherently dangerous activity, resulting, for example, in escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate vis-a-vis the tortious principle of strict liability under the rule in Ryland versus Fletcher, my lord. Not then it looks, learned single judge looks at the way in which this has been made applicable in respect of cases of electrocution, which is in Shel Kumari, my lord, which is in the next paragraph. In that, in fact, my lord, what had happened is that a worker who was going back from the factory, when he was riding on his cycle, he goes over a live electric wire and then he's electrocuted. I'll just go to the extract from the judgments of in Shel Kumari, my lord, at paragraph 7. It is an admitted fact that the responsibility to supply electric energy in the particular locality was statutorily conferred on the board if the energy so transmitted causes injury or death of a human being who gets unknowingly trapped into it. The primary liability compensates the sufferer is that of the supplier of the electric energy. So long as the voltage of electricity transmitted through the wires is potentially of dangerous dimensions, the manager of its supply have the added duty to take all safety measures to prevent escape of such energy or to see that the wire snap would not remain live on the road as users of such road would be under peril. It is no defense on the part of the management of the board that somebody committed mischief by siphoning some energy to his property and that the electrocution was from such diverted line. It is a lookout of the managers of the supply system to prevent such pilferage by installing necessary devices. At any rate, if any live wire got snapped and fell on the public road, the electric current thereupon should automatically have been disrupted. Authority managing such dangerous commodities have extra duty to chalk out measures to prevent such mishaps. Then, my lord, at paragraph 8, even assuming that all such measures have been adopted, a person undertaking an activity involving hazardous or risky exposure to human life is liable under law of torts to compensate for the injury suffered by any other person, irrespective of any negligence or carelessness on the part of the managers of such undertaking. The basis of such liability is the foreseeable risk inherent in the very nature of such activity. The liability cast on such persons is known in law as strict liability. It differs from the liability which arises on account of the negligence or fault in this way. That is, the concept of negligence comprehends that the foreseeable harm could be avoided by taking reasonable precautions. If the defendant did all that which could be done for avoiding the harm, he cannot be held liable when the action is based on any negligence attributed. But such consideration is not relevant in cases of strict liability, where the defendant is held liable irrespective of whether he could have avoided the particular harm by taking precautions. Therefore, my lord, the law laid down in Shell Kumari is that this is not a case where the issue of negligence is something that one has to go into. It is a case of strict liability and absolute liability where the defenses that would otherwise have been available to them would not be available. So for them to say that we have taken all precautions and there is no finding in respect of negligence, and therefore we cannot be held to be liable, that is not a defense that is available to them as long as in respect of cases of electrocution, my lord. So that is my submission, is what the Honorable Supreme Court has clearly laid down insofar as the case in Shell Kumari is concerned.
Shell Kumari,
Please.
the facts were different. Facts, you have to see in fact.
Please.
It appears.
Please.
Live wire was lying on the ground. And when whosoever was there, they was riding the bicycle, came over that live wire and got electrocuted.
Please.
That can be said to be a case of sheer negligence on their part. The live wire lying on the road, possibly it's a negligence. But what if in a normal circumstances, everything is in place? But because of the overt act on the part of one of the persons, when she wanted to remove the wheel, that she got electrocuted. How would you answer that?
Please, my lords. My lords, I see what my lords is saying insofar as the facts in Shell Kumari is
Exactly, we
concerned.
have to see in facts.
But my lord, my submission would be that certainly in those facts, there was a live wire. In fact, my lord, I'll come to Bhagyabai's case. And in Bhagyabai's case, my lord, which was decided by this court, the facts in that case was that there was a fence that was illegally electrified. And the person concerned, he came in contact with that electrified fence and thereafter passed away. In that also, there were two defenses that were taken. One, that it was illegally electrified. So therefore, they cannot be held to be liable. Second defense that was taken in that particular case, my lords, was that the person came in contact with that fence and therefore, again, they could not be held to be liable since they have taken all precautions that are necessary to be taken. The principle that was followed by this division bench, also looking at what has been held by the apex court, is that certainly, my lord, the facts in that are in respect of a live wire that was fallen on the ground. But the principle laid down that in respect of cases of electrocution, the principle of strict liability that applies would not allow for such a defense to be taken because the nature of electricity is that hazardous, is so dangerous that they would be absolutely liable for it without any recourse to a defense. And while the facts in Shell Kumari may be different, my lords, the principle that is laid down is what has been followed. So my submission would be that, yes, my lord, the facts were different, but the principle that has been laid down in respect of strict liability, following the judgment in MC Mehta, clearly makes out that this defense is not applicable. As it happens, my lord, insofar as the first case is concerned, where the young boy goes to the terrace and he comes in contact with the induction zone, where they say that they have issued a notice to that house owner. The fact of the matter is that they were aware of the existence of that building. They had allowed it to continue. They had not taken any action. They had even taken an undertaking. So there, my lord, there is a very clear act of negligence also to be considered.
We will deal it separately.
Please, my lord. Very well. But the principle of strict liability, my lord, is what is applicable insofar as cases of electrocution are concerned. And in fact, after Shail Kumari, there have been a series of judgments which I have relied upon where the,
See those.
please, my lords. Lord, there is one more aspect of negligence which I will come to subsequently, which has also been dealt with by the learned single judge, is whether contributory negligence or negligence could be attributed to children. That is another aspect, my lord. I will come to that separately after answering, my lords. The first judgment, my lord, in my compilation is of Shail Kumari. So since I have already read that out, my lord, I'll not trouble my lords with that. Except, my lord, at page 4 of Shail Kumari, where the Apex Court has looked at this principle. At para 10, my lord.
Which one?
Page 4, my lord.
Shail Kumari?
Please, my lords. I had said at page 4, my lord, I read out para 7 and 8, which has been extracted in the judgment of the learned single judge. Thereafter, my lords, para 10, there are 7 exceptions formulated by means of case law to the doctrine of strict liability. It is unnecessary to enumerate those exceptions, barring one, which is this, an act of stranger. That is, if the escape was caused by the unforeseeable act of a stranger, the rule does not apply. Thereafter, my lords, at para 12, the Apex Court looks at the judgment in MC Mehta's case. And at para 13, my lord, in the present case, the board made an endeavor to rely on the exception to the rule of strict liability, Ryland versus Fletcher, being an act of stranger. The said exception is not applicable to the board, as the act attributable to the third respondent should reasonably have been anticipated or attributed to the third respondent, should reasonably have anticipated at any rate, its consequences should have been prevented by the appellant board. In Northwestern Utilities Limited versus London Guarantee and Accident Company Limited, the Privy Council repelled the contention of the defendant based on the aforesaid exception. In that case, a hotel belonging to the plaintiff was destroyed in a fire caused by the escape and ignition of natural gas. The gas had percolated into the hotel basement from a fractured welded joint in an immediate pressure main situated below the street level and belonging to the defendants, which is a public utility company. The fracture was caused during the construction involving underground work by a third party. The Privy Council held that the risk involved in the operation undertaken by the defendant was so great that a higher degree of care was expected of him, since the defendant ought to have appreciated the possibility. And the act of stranger, my lord, in fact, which was a defense that was even taken there, because they said that the live wire was not their responsibility. That has been negated. This judgment, my lord, was subsequently followed at page 7, my lord, the second judgment, 2004-5, volume 5, Supreme Court cases 793, HSEB and others versus Ramnath and others. In this case, my lord, the facts are at para 1. It's against the judgment of the High Court dated so and so. It appears that a 5-year-old child died as a result of coming into contact with a high tension wire, which passed over the roof of their house. The parents therefore filed a writ petition claiming compensation against the appellants. The High Court, applying the principles of res ipsa loquitur, directed payment of rupees 1 lakh as compensation. At para 6, my lord, on the next page. The appellants are carrying on a business which is inherently dangerous. If a person were to come into contact with a high tension wire, he is bound to receive serious injury and or die. And they are carrying on a business which is inherently dangerous. The appellants would have to ensure that no injury results from their activity. If they find that unauthorized constructions have been put up close to their wires, it is their duty to ensure that the construction is got demolished by moving the appropriate authorities and if necessary by moving a court of law. Otherwise, they would take the consequences of their inaction. If there are complaints that these wires are drooping and almost touching houses, they have to ensure that the required distance is kept between the houses and the wires, even though the houses be unauthorized. In this case, we do not find any dispute question of fact, as the child has come in contact with a live wire and has succumbed to her injuries, and now with the compensation of rupees 1 lakh was, in that case, my lord, in 2004, the compensation of 1 lakh was paid insofar as the child is concerned. The third judgment, my lord, is the judgment of our division bench in Bhagyabai's case, which I had relied upon earlier, my lord. My lord, I narrated the facts of this case where they said that the fence had been illegally electrified at page 14, ink page 14.
So there.
Please,
there
my
cannot
lords.
be any dispute.
Please. So therefore, my lord, this court, my lord, in this has relied upon Shail Kumari to say that strict liability is applicable, and therefore the defenses that would have been otherwise would be available to them under Allen versus Fletcher, including perhaps negligence, is something that would not be available to them to take. So therefore, since my lord is also looking at this particular case where there may have not been any overt act of negligence on their end,
So this only we are putting it to you so that you.
Please,
can
my lords.
respond.
Please, my lord. So therefore, when the principle of strict and absolute liability is made applicable, that defense is no longer available to them, my lord. And that,
No defense is available.
please, my lords, it is not available to,
Bottom line, no defense.
please, my lord, that is precisely what the apex court has held in light of the fact that once there is something that is dangerous and hazardous that is being brought, then one cannot take that defense when there is any injury or death caused because of that.
Would you compare an oleum gas with the electricity transmission lines?
My lord, the principle that has,
Except from
please,
these facts which you have said, where there is an illegally, they have put a, wiring. which
Please.
Was electrified.
please.
Those are surely. But in every case, it has to be seen strict liability without there being any defense. We wanted to know that. Is it the case?
Please, my lords. My lords, what the principle of strict liability ensues is that it is dependent on the nature of the product, so to speak, that is coming out. For example, my lord, in MC Mehta's case, it was oleum gas. Here, my lord, electricity, and that is what the apex court has held. That is inherently dangerous, inherently hazardous, and therefore the defense that would otherwise be available to them would not be available in these instant
So
cases.
what are the precautions need to be taken?
Please, my
Let's
lord.
assume in the facts by the
Please.
electricity department.
Please, my lord, the Electricity Act 2003, and subsequently the regulations that have been framed in respect of safety, which was brought out in 2010, my lord, they detail out some of these provisions which are required to be complied with. But my lords, to my lord's question, as to let us assume that they are complied with, then would they still be liable? To respond to my lord's question on that, the principle, again, my lord, what has been laid down would mean that they are in fact liable for that. And because all the precautions that are required to be taken are required to be taken, and anything unforeseeable also ought to have been foreseen by them. That's what in fact the apex court holds, that therefore, even if, let us assume for a moment that all the precautions have been taken, and I'll take my lords to the facts in the other case as well to show that. But even if one were to presume that the principle of strict and absolute liability, in
But
fact,
tell us
looks at
one
this.
thing, in one
Please.
of the cases where, because of the induction,
Please, my lords.
the transmission line were at an appropriate height
Yes.
as what is contemplated under the provisions. But because of the construction of the building at a particular height, which decreasing the height, the distance between the transmission line and the terrace, bringing it within the scope of that induction, which resulted in the accident. How would you answer such a thing? Then also it would be strict liability?
My lord, that is the principle that has been laid down, would be my submission. I will also take my, please.
Strict liability
Yes.
at whose part? Would be the transmission or the persons who have actually, allowed that building to come up?
My lord, what has been held is that those who are transmitting, who is transmitting this power is who would be liable. Because when, my lord, what, if I may just repeat myself, what has in fact been, what was specifically mentioned, my lord, it is the business of electricity is inherently dangerous. So when when you're dealing with an inherently dangerous and inherently hazardous
No, but that would be read in the context.
Please.
If there is a negligent act, it is a
Please.
strict liability. Negligent act on the part of the electricity department, like, they have left a cable unattended, because of which there is no electrocution. There is a negligence. Nothing more need to be seen. That's enough. And they were required to take all precaution to ensure the cable doesn't lie there, because inherently it's a hazardous or dangerous. So they have that obligation is there on their part to ensure it. Those precautions are taken, and there is nothing of that sort happens. But in a case where everything is in place, but still something happens, how would you answer that?
My lord, in fact, what has been held.
I hope we are.
Yes, my lord.
You are clear.
My lord, if I understood, my lords, that this is if we have a case where all precautions that are required to be taken have been taken, and there are nothing left to be done by the
Yes.
electricity transmission company, then what would be the nature of liability that would rest upon them? What the court has held, my lord, in fact, the defense that was taken in Shell Kumari is that there was no negligence. Is that I did everything that I could have done. That whatever needed to be done from my end was done.
So there was a live cable lying on the ground.
Yes, my lord, but the defense that was taken by them was that we are not, there was no negligence on our part. That was a defense taken, my lord. If one were to look at what forms the basis for that judgment, the defense taken by the company there was that there was no negligence on their part. They did everything that was required to be done. And it was maybe a third person who did it. But the principle being that they didn't do anything wrong. That is the defense that has been taken by them. And it's in that context, my lord, where they say that my lord, in fact, if I may just read from para 8 at page 4. The last few lines, my lords. If the defendant did all that which could be done for avoiding the harm, he cannot be held liable when the action is based on any negligence attributed. But such consideration is not relevant in cases of strict liability. I'm reading the last 4 lines, my lord. Where the defendant is held liable, irrespective of whether he could have avoided the particular harm by taking precautions. So the principle that is laid down is that that the nature of liability is such that even if they say that they have done everything that is required to be done, because the electricity is something that is so dangerous and hazardous. In fact, my lord, the distinction is laid down by the Honorable Court. The para 8, my lord, I'll just keep the first 4 lines, my lord. The basis of such liability is the foreseeable risk inherent in the very nature of such activity. The liability cast on such person is known in law as strict liability. It differs from the liability which arises on account of the negligence or fault in this way. That is, the concept of negligence comprehends that the foreseeable harm could be avoided by taking reasonable precaution. So therefore, my lord, what has been held by the Apex Court is that whether there is an act of negligence or not is not something that can be looked at when the principle of strict liability comes in. Okay. My lord, since my lords has the judgments, if I may just take my lords through the other judgment, where in fact, my lord, in Naval Kumar versus State of Himachal Pradesh, this is another case where a young boy was electrocuted. In fact, in that, it's at page 26 of my compilation, man. And my lords may also say that the Bhagia Bai's judgment was actually was upheld by the Supreme Court. I have placed the order at page 24, where where BESCOM in that case BESCOM is the respondent number. Is the appellant in respect of the girl, my lord, in respect of The 13-year-old girl, the appellant is Bescom, the Bangalore Electricity Supply Company. They had challenged that order before the Apex Court, and the Apex Court had rejected the same. In the order of the Himachal Pradesh High Court, which is at paragraph 26, which was subsequently upheld by the Apex Court, except to reduce the amount of compensation. At page 49, if my lord would see.
Yes.
Please. The Honorable Court looks at the judgment of the Supreme Court in Shail Kumari's case, and thereafter, my lord, in page para 40 on the next page, the court relies upon the judgment of the Supreme Court in the HSEB versus Ramnath case, which I had also which I have placed. And then, my lord, at para 42, looks at the judgment of the Honorable Supreme Court in the case of Nilabati Bera versus State of Orissa, to look at the claim in public law for compensation for contravention of human rights. In this particular case, my lord, the amount of compensation that was awarded by the Himachal Pradesh High Court was 1 crore 30 lakhs. It was taken in the Supreme Court, my lord. This, I'm so sorry, my lord. This is the Supreme Court judgment. It was reduced to 90 lakhs. So this is the judgment that where they have actually that has been done. The judgment what I was reading out was the order of the Supreme Court, my lord. Then, my lord, in the subsequent judgment, at page 69, is the judgment of the Supreme Court in Raman versus Uttar Haryana Bijli Vitran, where also the High Court has awarded compensation, and that has been upheld by the Supreme Court on the same principles. So therefore, my lords, in respect of the nature of liability concern of the appellant, the principle of strict liability would apply. And therefore, for them to say that there's no negligence on their part, or that there was some overt act on the part of the respondent concerned, that would not be something that would be available for them. I had also mentioned that in respect of children, the principle of contributory negligence, it has been held, my lord, that that principle cannot be made applicable. That, my lord, has been dealt with by the learned single judge as well. The principle of contributory negligence, my lord, is at page 86 of the order of the learned single judge. Page 86, my lord, point F, contributory negligence of child. It is a contention of the respondent in writ petition number 53302 of 2018 that the 13-year-old victim has come in contact with the electric line only by virtue of the iron mob that was being carried, and accordingly the victim had contributed to the accident. At para 35, my lord, it is to be noted that the Apex Court in the case of Sudhir Kumar Rana versus Surinder Singh has observed at para 4 to 6 as follows. The question which arises for consideration is as to whether the appellant can be said to be guilty of contributory negligence. Ordinarily, the doctrine of contributory negligence is not applicable in case of children with the same force as in the case of adults. We do not intend to lay down a law that a child can never be guilty of a contributory negligence, but ordinarily this seems a question of fact. A contributory negligence may be defined as negligence in not avoiding the consequence arising from the negligence of some other person, which means an opportunity are afforded to do. Question of contributory negligence would arise only when both parties are found to be negligent. And at para 37, my lord. In Abdul Rahman, eventually the division bench of Madhya Pradesh High Court has rejected the claim of contributory negligence on a child's part. Para 11 of the said judgment is extracted as below. From the aforesaid discussion relating to contributory negligence on the part of a child of tender age, there's no doubt that the concept of contributory negligence cannot be made applicable to a child. A child functions according to his own reasoning and his intelligence. Logicality and rationality are not expected from a child. The child of tender age has no continuous thinking process and is governed by his impulsive instinct and innocence. Can one ever conceive that a child, if would have been aware of the peril, would ever commit an act which is dangerous or hazardous for him? The answer has to be a categorical no, because a child's action is childlike and really innocent. Possibility for that reason, it has been said. The principle of contributory negligence, whether it can be attributable to which children, my lord, it has been looked at. And this is a judgment I have also placed along with my compilation, where it has been held that one cannot apply it in the same manner. In any event, my lord, my submission is that the question of negligence is not one that comes into this particular case, in light of the fact that the principle of strict and absolute liability would apply in these cases. The judgment that was relied upon by the appellants
One on the
yes, my lord, by the division bench of this court, my lord.
maintainability of the writ petition.
Please, my lords.
Or the learned judge could not have decided the total compensation.
Please, my lords.
Should have possibly awarded an interim compensation, relegated the parties.
Please, my lord, insofar as that is concerned, the judgments that I have relied upon. One, my lord, in Bhagyabai's case, where this court did not relegate them back to the civil court. And in fact, that was an argument that was made, that they should be relegated to the civil court. There, the principles under the Motor Vehicles Act has been used to compute the compensation that is payable. That was a case where a worker died. So the principle of the principles under the Motor Vehicles Act has been used, my lords. Thereafter, my lords, in Naval Kumar's case, which I had taken my lords through, it is again, they don't really.
What were the facts in that? Let's see that.
In Naval Kumar, my lord?
No.
Bhagyabai's.
Yes.
Please, my lords. It's at page 24 of my compilation.
I just wanted to see the facts.
Please. I'm sorry, my lord. It's at page 10 of my compilation.
To page 12.
Yes, my lords. At paragraph 2 are the facts.
That's illegally electrified fence.
Yes, my lord. That's the illegally electrified fence. And the.
Then, see,
Yes.
possibly. There is no contest or an issue with regard to whether that fence could have been there. It could not have been there. Illegally, it could not have been there. But it was there, it resulted in accident. So in the facts, possibly, there are no dispute illegally. Then the only issue before the court was what should be the compensation. Then it applied those principles under the Motor Vehicles Act and granted the compensation. That's how possibly. How would you answer that?
The defense that was taken in that particular case, in Bhagyabai's case, which has been noted, is that the fence was electrified illegally by some other person. So it is an act of a third person, and therefore it's an act of a stranger, and therefore they could not be held liable. That was what was looked at.
Okay.
In fact, my lord, in that particular case, the writ petition had been dismissed on the ground of maintainability, saying that there are disputed questions of fact. And it was in the writ appeal that this honorable court has passed this order. The writ petition itself was originally dismissed on the ground of disputed questions of fact. In this, my lord, at paragraph 7, this court has looked at the judgment in Madhya Pradesh Electricity Board versus Shail Kumari. And at paragraph 10, my lord, is where this has been considered.
Shail Kumari was considered?
Yes, my lord. Shell Kumari is considered at paragraph 7. Shell Kumari is considered
How is the liability fastened on the electrical,
the
respondent?
owner of the, in this, my lord, what was done, if my lord would see the,
We'll do one thing, we'll continue.
please, my lord. In fact, my lord, what the learned single judge does is also to say that if they feel that there is somebody else who is liable, the liberty is reserved to them to actually take necessary steps in so far as that is concerned. And that was in fact something that was also done in Bhagyabai's case, where liberty was reserved to them to take action in that, on that front.
Okay. When do you want? We'll have it day after tomorrow.
Thursday, my lord,
Huh?
please.
No.
Wednesday is a holiday.
Huh? Oh, Wednesday or Thursday. Notice has to go. We will dispense with it. There is no need to issue notice to the Karnataka State Commission for Protection of Child Rights.
May not be necessary, my lord.
Notice has gone.
At the time that we had filed it, that order was there. It's-
Quasi judicial, they should not come and they will not come and justify their order.
And it's not.
The respondent number 3 in this appeal is Karnataka State Commission for Protection of Child Rights, which had submitted its report.
It had passed an order, in fact, initially. They had initially given a recommendation for payment of a certain sum of
Being a
compensation.
recommendatory body or a quasi judicial?
Recommendatory body, my lord. They had
Recommendatory
passed.
body, the notice to the said commission is
Statutory.
dispensed with. Huh. And further, there is no relief against them. And further, just say that, further, there is no relief has been sought against the commission. And hence, notice to the said commission is dispensed with.
Please.
That's all.
In both the matters?
In two
10.1
matters,
and 10.2, my lord. They are in 10.1 and 10.
in the same order.
5 and 868.
There is a dispensation order in the previous one. It shows.
In fact, my lord, I think it has already been dispensed with, my lord, by the order dated 12/9/20.
One of the appeals is dispensed with.
Please, my lord. In 865 of 22, by the order dated 12/9/2022.
But they just say so dispense with. Thank you.
Good. Super.
This is a big-